Committee to order. I'm required to read a statement. As chair of the House Judiciary Committee, I find that due to the state of emergency.
Yeah, we're not in good shape now.
Ned, you have to speak into your microphone.
I am sorry.
You didn't begin by saying, "Can you hear me?" You see, that was your problem.
That must be the difference.
Right.
As chair of the House Judiciary Committee, I find that due to the state of emergency declared by the governor as a result of the COVID-19 pandemic, and in accordance with House Rule 67 and the governor's emergency order number 12, pursuant to Executive Order 2020-04, this public body is authorized to meet electronically. This is a public hearing of bills referred to the Judiciary Committee. Executive session on pending legislation may be held, although I'm not intending to do that today. Please note that there is no physical location for members of the public to observe and listen contemporaneously to this meeting. However, in accordance with the emergency order, I am confirming that all members of the committee and select legislative staff have the ability to communicate contemporaneously during this meeting through the Zoom electronic meeting platform. And the public has access to contemporaneously listen and, if necessary, participate in this meeting by Zoom platform or by telephone. All necessary access information has been made available in the House calendar and through the electronic calendar on the General Court website. The notice for this meeting complies with House rules and RSA 91A, right to know law. Anyone who has a problem accessing the meeting should call 271-3600 or email hcs@leg.state.nh.us. In the event the public is unable to access the meeting will be adjourned and rescheduled. We do have a staff member who is participating today, and that is Jennifer Four, our committee researcher. She won't be actually participating in the meeting, but will be monitoring the meeting. Please note that all votes that are taken during the meeting shall be done by roll call vote. We'll begin the meeting by taking roll call attendance. When each member states their presence, please also state whether there is anyone in the room with them during the meeting, which is required under the right to know law. And I'll begin by saying I'm Ned Gordon. I'm at my house in Bristol, New Hampshire, and my wife may be in and out of the room at times. And Mr. Clerk, would you call the roll?
Yes, Mr. Chairman, it's my pleasure to do so. Representative McLean is not here. Is that right?
Don't see him.
So we have to work. Representative Sylvia.
Good morning. If you can hear me, I am actually in my mobile office today for at least the first hour, listening and taking care of urgent business. I am currently in Belmont. I will go to Tilton and then back to Belmont to my home office. I'll be there by 10 o'clock. And I'm alone.
Thank you. Representative Welker is here in MLB 208. He's alone. Representative Alexander. Representative Alexander. Told me he had to work. Representative Rice. Representative Rice. Representative Silver.
I'm here in my home office in Guilford by myself.
Figure out where I am. Silver. Representative Green. Representative Green. Must be exhausted from the week. And Representative Kelly.
I'm here alone in Temple with my dog.
Oh. Representative Tosh. Representative Tosh. Representative Chartier.
Good morning. I'm here in my home office in Belmont. I am alone.
Thank you. Representative Smith.
Good morning. I'm alone in Durham.
Representative Burris.
And good morning. I am alone and I'm in Westmoreland.
Representative Horgan. Representative Horgan. Representative Horgan is probably at the executive committee meeting that I'm missing this morning. Chair of my subcommittee. Representative DiLorenzo.
Good morning. I'm here in my home office in Newmarket and I'm alone.
Representative Chase.
Rollinsford in my home with my cats.
Representative Kenny.
Good morning. I'm here in Durham alone. Roommates may be through the room throughout the day. Thank you.
Representative Langley.
Good morning. I'm here in Manchester with my husband at home.
Representative Macbeth. Representative Macbeth. Representative Page.
Morning. I'm in Exeter in my home office, but children in the house. Thank you.
Representative Simpson.
Good morning. I'm at home in Exeter and I'm alone now. My husband and two sons might be in and out during the day.
Thank you. 3, 4, 5, 6, 7. Wow. Okay, that completes the calling of the roll. We have 14 members present, Mr. Chair.
Thank you, Mr. Clerk. Our first bill this morning is House Bill 133. It's a bill creating a cause of action for censorship by social media websites. Primary sponsor of that bill is Representative Plett. And is Representative Plett available to testify this morning? I see that he is.
Can you hear me?
We can, Representative.
Thank you. This bill is simple. It creates a vehicle for people to sue social media for blocking content. And of course, not all content. If it's injurious to children or indecent, there's no such right. But otherwise, if it's a point of view that the social media doesn't like, they've been shutting people down. And that infringes right on the Second Amendment. They've got some protections in federal law, but this won't conflict with federal law because there's a state carve out in that federal law. And if, depending on your political viewpoint, you might want some things to be shut down that you don't agree with, but the worm turns. And we need to protect our First Amendment rights. If I said second, I meant First Amendment rights for free speech. And that's the gist of it. I had a late amendment which changes the amount that could be sued up to $75,000 rather than minimum of $75,000. But that's the gist of it.
Okay, are there questions for Representative Plett? Maybe you could just explain to me what was the impetus for this? Is there a particular problem in New Hampshire that you're aware of that this is directed at?
It's happening across the country. It's happened to my son, who happens to be an anti-vaxxer in California. He's been shut down several times after developing followings of 30,000 plus on Twitter. It's happening in New Hampshire. I don't have a specific example, but yes, it's happening everywhere.
And I guess that's just a follow up to that question. You indicated anti-vaxxer, your son being an anti-vaxxer, and I'm presuming that a social media site has indicated that his talking about anti-vaccination is prohibited on their site.
Period. Yes, it shut him down several times. This is one example because it's a personal example that I'm aware of, but it's no problem finding people to come forward and say there's a concern here in New Hampshire. It's something, if they have ties with the pharmaceutical industry, they're going to shut them down because it's a bread and butter to them. It may be political points of view they don't particularly care for. And we've seen examples of that.
Are there other questions? Yes, Representative Birch.
Thank you, Mr. Chairman, and thank you, Representative, for taking my question. I'm generally not a conservative in my political outlook, though there are some aspects that I believe in. But I have a question about the idea that the state of New Hampshire, according to this bill, should be telling private companies what they, how they do their business in terms of what they allow to be posted and what they don't allow to be posted. So are you comfortable with saying to private companies what their speech, what speech they allow and what speech they don't?
There's a point in time when a private company gets so big that it becomes a common carrier, and should be open to all. If it's a small entity, not so big a deal. But when they get it to be as big as Facebook and Twitter, they have control over messages, and that does become a concern.
Thank you.
Yes. Are there other questions for Representative Platt? Seeing none, thank you for your testimony today.
Thank you. Appreciate the time.
Not a problem. And we do have other people who have signed up to testify here today. There was Elizabeth Ellis. Is Elizabeth Ellis available? I don't see Elizabeth Ellis on the list of attendees. And Sherry Womack. And I don't see Sherry Womack on the list of attendees. And Christine Wheel. Yes, I see there is a Christine with her hand up.
Hi there. Thank you so much for your time. So I am in support of House Bill 133. My name is Christine Wheely. I have One Heart Ministries. I'm in Minnesota, but I also am part of the Special Forces of Liberty. And I wanted to just address really quickly the point that y'all made about how this affects people in New Hampshire. So my ministry is nationwide, and we have connections with people in New Hampshire, and I personally have been censored. So I can give an example, but I think the main thing is that the major social media websites, they've reached a critical mass, and they have done it basically through fraud, false advertising, and deceptive trade practices. And because Facebook, Twitter, and all of those media sites are so large now, people like me and other people, constituents in your state, you know, when we're censored, for instance, well, my example was, you know, I posted something in regards to my time of ministry in Nevada that was censored and was told it was sexually explicit, when that was absolutely not at all anything, and nothing, not one thing in there was that. It was a video of the Nevada state government signing the 6 electoral votes or whatever for Trump, but it was not even like, it was an answer to my prayer, specifically of my time in Nevada. That was censored and said it was sexually explicit. So that is happening. That's just one example. And so we, you know, as a citizen, we and the people in New Hampshire, those that I know, even on Facebook, who see those posts and things, it's taken away our rights, and it's taken away, you know, regardless of political party or religious views, social media should not be censoring its users in the way that they are. And we all know that that is happening. And so I personally, I support this bill and am running this legislation across because I hear of all the stories whether it's a Democrat, Republican, none of that really matters. It's really about just them taking control over, you know, they have their own interest in mind. And so this will give a right to those citizens who have been defamed, who have been censored, to actually, you know, stand up for themselves and with the and be able to sue with that $75,000, which in some cases it has.
Well, Christine, I think you got muted for some reason.
I think my phone muted, or I was muted.
Yeah, it did briefly there.
Okay. So anyhow.
And it seems to have happened again.
Yeah, sorry, keep me out here.
I hope that's not the social media.
Oh, I've been having some issues already. Just let me tell you that. So just doing this, everything's crazy. I was censored yesterday. I was censored yesterday personally with my prayers going forth in a messenger voicemail. I do voice messaging because I don't always have time to type. And I have people in other states who have cancer and who I've prayed for, and I could only, you know, do the voice recording, and they did not get any of that. And they had surgery yesterday. So that is my personal example to bring it down to a personal level. This isn't just me. That was someone I was praying for in Texas who I have a relationship with. So yeah, anyhow, thank you so much. I'm just going to end it with that. I mean, we all know this bill just speaks for itself. So.
Okay. Are there any questions for Ms. Wheatley? If not, thank you for your testimony today.
Thank you.
And are there other people in attendance today who would like to testify? I see that there is a Cam Willett with a hand up. So if Cam Willett would like to testify.
Good morning. Thank you for your time today. My name is Cam Olet from New London. I work with Special Forces of Liberty. Please consider being a co-author to the Stop Social Media Censorship Act, HB 133, and vote in favor of this bill. I see so much censorship with my fellow citizens, sharing truth that is challenged by big dollar corporations such as pharmaceutical companies, government-run programs, and other wealthy influences. Our First Amendment rights are not for sale. There must be a free exchange of ideas and freedom to make them known. Private companies are operating under the guise of public free exchange of ideas and now have grown so big, they now choose the narrative that people are allowed to see. Literal hate speech and child porn is allowed, and although reported, is considered not against community standards. But people are literally dying and suffering for life because of lack of access to informed consent for medical interventions. Our country is dying because of lack of performance of civil duty. This is not taught in our educational institutions. Adults are concerned over the destruction of freedom in America to pursue life, liberty, and happiness, our God-given right as written in America's founding documents. People are wanting information on how to be involved in their local government process and connect with local people who want to do the same. And it is being censored by big tech because that somehow goes against community standards. Please support freedom and vote in favor of HB 133. Thank you.
Are there any questions for Ms. Willett? So the bill itself, as I understand it, deals specifically, it prohibits a social media company from censoring political or religious speech. And do you have specific examples of that in New Hampshire where this would apply?
Yes, when posting information on local political gatherings or trying to gather fellow citizens or sharing information regarding medical interventions, Facebook will remove posts. They will hide, like if we post a picture with a quote from a doctor, Facebook will hide it, saying that the information goes against community standards or is harmful content. When we should be according to our constitutional rights, our God-given rights, we have the right to pursue the information that we deem necessary for the health and well-being so that we can pursue life, liberty, and happiness.
Thank you. Are there any other questions for Ms. Willett? Seeing none, thank you for your testimony.
Thank you.
And we have Christopher Sevier Esquire.
Thank you.
Sevier.
Yes, sir. Thank you, Mr. Chairman. Thank you, members of the committee. I'm going to talk very fast. Please welcome to answer. I can answer any questions you have. I want to make 5 points. First, I want to give you, 4 points. I want to give you a quick background. Number one, 29 other states are carrying this bill. Both Democrats and Republicans are the prime sponsor of this bill. It was written out of a lot of, this has been litigated a lot in federal district court. It is one of the hottest topics in the country. It's a bipartisan issue. My background, very quickly, I went to Vanderbilt undergrad, Vanderbilt Law School, was a judge advocate general, and worked briefly as assistant United States attorney. Here's 4 points. Number one, well, the question presented is, what's the best solution to the ongoing problem of social media censorship, which is completely out of control? Is it an executive order by the president? Is it Senator Josh Hawley's attempts to repeal Section 230 of the Communications Decency Act? Or is it Representative Plett's bill, House Bill 133? And the answer is it's Representative Plett's bill, because it falls within what's called the state law exemption under Section 230. It's subsection E, paragraph 3. And so what does that mean in plain English? What is Section 230? Well, Section 230 is a statute created by the federal Congress in the 1990s that creates immunity for internet intermediaries. And the way I have to understand it is through an example. So the best way to understand it is if someone posts a defamatory comment on YouTube, the defamed party can sue the person that defamed them. But if they name YouTube in the lawsuit, then YouTube could invoke a Section 230 immunity defense and be dismissed from the case. So that's a good use of Section 230. It's actually good law, but it's being abused in New Hampshire substantially. It's being abused in this way. When people in this state get censored for their religious or political worldviews, and they try to bring any kind of cause of action against tech, tech companies are then invoking Section 230 immunity defense and saying, Your Honor, we're merely editorializing. And so our position is that Section 230 of the Communications Decency Act was created to protect decent speech. It was never created to promote deceptive trade practices. So that's point one. The best solution is Representative Plett's bill. Point two is, what does this bill say? The Stop Social House Bill 133 says this. It says, going forward in the state of New Hampshire, any retailer, it says going forward, if a social media website censors a user for religious or political speech, and that social media website was always marketing itself from its inception as being free, fair, and open to the public, and if they have more than 75 million subscribers, if that kind of social media website censors, then the injured party can seek up to $75,000 in statutory damages, attorney's fees, actual damages, and other forms of relief. $75,000 is a magic number because it gives a litigant the option to litigate in federal district court or in state court under what's called diversity jurisdiction. The fact that it says the injured party can seek attorney's fees means that local lawyers would have incentive to represent your constituents when they're being censored and shut down by social media websites, because of a thing called the American Rule, which says you got to have a statute that allows there to be recovery in order for a litigant to seek that. So point three, this is very important. Contract law is a state law issue. Now, when you sign up for social media websites, you're entering into an adhesion contract, which means the courts won't really take it very seriously. However, those social media websites are reaching into New Hampshire and inducing your constituents to sign up to use their services. And when those, contract law is a state law issue, and when your constituent signs up for Facebook, Twitter, or YouTube, and after they've been promised that it's free, fair, and open to all ideas, only to turn around and be censored. Okay, that's what Attorney General Barr called it, the greatest bait and switch of all time. But that kind of commercial practice amounts to breach of contract, bad faith, unfair dealing, unjust enrichment, fraudulent inducement. This is a deceptive trade practice bill. It's a progressive bill, really, because it gets existing law to catch up to modern day technology. Point three, the underlying constitutional federal legal prescription for this bill is the First Amendment free exercise clause, and the free speech clause of the First Amendment. Now, New Hampshire's Constitution says the same thing, because the First Amendment applies to the government. It restrains the government from encroaching on free speech. So it's really a restraint, but it can be used as a trampoline, as a catalyst when in a situation like this, where the tech companies have set out purposely to induce people to sign up to their websites only to turn around and censor them. They've induced people to sign up because they've marketed themselves as being open to ideas, and they've reached critical mass as a result of that. They have set out and purposely created a digital public square. For them to turn around and censor your constituents now is per se deceptive trade practice. Deceptive trade practice is not a protected form of free speech. The opponents of this bill generally show. I want to make one more point and I'll stop.
Yeah, if you
Yes,
would
sir.
just kind of wrap up.
Yes, sir. Sorry, this is very complex First Amendment law, so I'm just trying to be helpful to the committee on that topic. Last point: there's some exemption as exceptions. They're common sense. If the issues are pornographic in nature, if it's calls to immediate acts of violence, if it's false impersonation, respectfully, Mr. Chairman, there are 3 proposed amendments we would suggest. We've had hearings on this bill in 7 different states this past week, and there's a couple of small amendments we've been picking up in different states. Number 1, we would recommend under subsection 8, subparagraph A, we recommend that a subparagraph, in addition to that, to be added under 8, that if the speech constitutes copyright or trademark infringement, that the social media website could censor that. If the content is excessively violent, that would be point number 9 under that same section, then they should be able to censor. And then finally, if the content constitutes harassing spam of a commercial, but not of a political or religious nature, they can be censored. And I'll stop with that. Thank you for giving me that extra time. If there's any questions, I'd be glad to try to answer those, and I'll stop there. Thank you so much, members.
Thank you. Yes, Representative Wolpert, do you have a question?
Yes, Mr. Sevier, did you submit all this in writing to us?
Yes, sir, I did. There's talking points. There's proposed legislative findings that we've used in other states that are a little bit more robust. It's all in writing. And yes, sir. Yes, sir.
Okay. Any other questions for Attorney Sevier? Seeing none, thank you for your testimony today.
Yes, sir. Thank you.
The next person is, and we do now have Elizabeth Ellis with us.
Good morning, Chairman Gordon. Can you hear me?
We can.
Oh, wonderful. Thank you. My name is Elizabeth Ellis, and I'm Vice President of State Government Affairs of the Motion Picture Association. I very much appreciate the opportunity to appear before you today to share MPAA's members' concerns regarding House Bill 133. MPAA member companies are the leading producers and distributors of motion pictures and other audiovisual works for all media platforms, including motion picture theaters, digital video home entertainment, cable, satellite, and broadcast television, as well as on the internet. Our members are no doubt familiar names to you: Walt Disney Studios, Paramount Pictures, Netflix, Universal Studios, Warner Brothers, and Sony Pictures. House Bill 1144 would create a new private right of action allowing a user, and I'm sorry, the bill was obviously 133, a private right of action allowing a user whose speech has been deleted to sue for $75,000 per deletion, plus actual damages, punitive damages, plus, quote, other forms of equitable relief if their online comment is removed. MPA member companies and their affiliates are hosts to platforms which allow viewers to post comments and reviews. And the definition of social media website in this bill is so broad that it would encompass many companies, such as MPA member companies, that allow users to share comments or product reviews online. MPA member company Disney, for example, owns ESPN, which allows sports fans to comment on online stories. And it's sometimes necessary, unfortunately, for Disney to remove certain inappropriate material shared by a user in their comment or review in order to ensure a positive online experience for the rest of their viewers. But by doing so, this bill could then make the Walt Disney Company liable for $75,000 every time they have to do this, plus equitable damages, punitive damages, and other forms of relief. While we don't believe our member companies are the intended targets of this legislation, the definition, as I said, is so broad that they unfortunately would fall squarely within the scope of this bill and the new liability that the bill would create, not just for our member companies, but for many larger businesses that allow user-generated content. We also believe the bill is unconstitutional as an invasion of the editorial process that's barred by the First Amendment. The First Amendment bars the state from interfering with editorial decisions, including by websites and internet platforms, about what to print or not to print. And we also believe House Bill 133 would be barred by Section 230 of the Communication Decency Act. Section 230, as you of course know, is the federal law that bars states from either imposing criminal liability or providing a civil cause of action against websites, platforms, social media sites, and ISPs related to user-generated content. For these reasons, we respectfully request the committee defeat House Bill 133. I would just like to add that while it is true that this bill is showing up in state houses around the country, it has been for several years now, and no legislature has ever enacted it. I very much appreciate the opportunity to appear before you today, and I'm happy to answer any questions.
Are there any questions for Ms. Ellis? Representative Wolper.
Yes, thank you, Mr. Chairman. Thank you for taking my question. Did you give us written testimony on this?
I will forward it right now.
Thank you.
Thank you.
Seeing no other questions, again, thank you for your testimony today.
Thank you.
And is there anyone else who would like to testify this morning on House Bill 133? Yes, I have a Cameron Schulte.
Good morning, Chairman Gordon. I appreciate your time this morning on House Bill 133. I'm the Director of Government Relations at the Heartland Institute. I will not belabor my points. I will submit my testimony to the committee afterwards. But a few points as I'm listening in, I did want to get to help with your decision-making on this bill. Particularly Representative Birch asked the question, how does House Bill 133 square with free market principles? And how does the state justify involving itself in what seems to be a private matter between a corporation and a user? Big tech operates in a government corrupted market. It exploits the government corrupted market to its advantage and opposes free market reforms, and therefore is not entitled to object to state government political free speech protections that allegedly violate those free markets. Free market objections to New Hampshire stepping up to protect free speech fails to recognize that the tech cartel neither formed nor operates under free market conditions. Big tech would not and could not exist without government favoritism and protection. Eliminating those favoritisms and protections is the ideal solution. However, in the absence of such an ideal solution existing or appearing imminent, Americans' vital free speech rights must trump corrupted market commercial interests. To that point a little bit further, industry opponents of this idea of providing redress for censorship and suppression enjoy a government-sanctioned market where the dominant players are largely immune to competition by which our economy is underpinned. That Section 230 of the 1996 Telecommunications Decency Act exists is prima facie evidence of a corrupted market. For big tech, the status quo is lucrative and rewards their own pious views while the users from which they profit are subject to their whims. I'll leave it at that, submit my written testimony to the committee, but I am happy to answer any questions.
Thank you very much, Mr. Schulte. Are there any questions from the committee members? Seeing none, thank you again. And is there anyone else who is in attendance who would like to testify? Seeing no one, we'll close the hearing this morning on House Bill 133. Next bill this morning is House Bill 453. That is a bill shielding journalists from mandatory disclosure of sources by subpoena. Primary sponsor of that bill is Representative Reed, and I'll call upon Representative Reed to provide testimony or introduce the bill if Representative Reed is available. And I don't, oh. Is that you, Representative?
It is indeed. Can you hear me?
We can.
Oh, excellent. I was afraid I wasn't being seen for a second. Thank you, Mr. Chair, and thank you, honorable members of the committee. I will be pretty brief, I think. For the record, my name is Ellen Reed. I represent Rockingham 17, which is Newmarket and Newfields. I also teach American government in community college, and every semester I teach my students quite a few things, but I teach them obviously about the First Amendment and the various parts of the First Amendment, one being the freedom of the press. I teach them about the importance of media, whether that influence be negative or positive on our democracy, how much of an influence the media can have. And most importantly, I think, or one of the most important things I teach them is the fragility of democracy. Most democracies have not stood for very long historically. We are the oldest still functioning democracy. And there are a few factors that lead to the stability of democracy. I won't belabor all of those, but I will emphasize that a well-informed public is absolutely crucial to a well-functioning democracy. Without a well-informed public, by definition, people cannot then have the information to make informed decisions on choosing their representatives. So the media is, and we've gone through a lot of recent years of issues with the media and integrity in the media, but the media is absolutely inextricably linked to the functioning of our democracy. In fact, it's called the fourth estate or fourth branch because of that. It is the way in which citizens have an ability to have a check on their government. And because of that, because of the importance of the media, I'm introducing this here, Reporter Shield Law. I do have to teach my students every year that despite the fact that we have a freedom of the press in some places in the country, and it has happened dozens and dozens of times in recent years, judges can jail reporters for not disclosing their sources. Now, it would be, and it is, whenever it happens, a tragic blow to democracy to weaken the media so that they cannot adequately source material. If their sources are unwilling to talk to them because they are afraid that they would be exposed, then simply put, the journalists can't really fully operate on the most sensitive and most important issues of our day. And we've seen issues like this when it comes to, well, I won't go, but there's obviously Edward Snowden and Julian Assange and all of these issues that have happened. But I just want to highlight the importance of a robust media that can source information, particularly when it's damning to the government, and particularly when those people who are sourcing that information, if they were exposed, might come to harm. So we are only one of 10 states that does not have a shield law in place in our current law. Most states have some level of protection. If we passed this bill as it stands right now, which is extremely broadly written, and I'll get to that in just one second, we would join 17 states that have absolute protection for journalists, states like Alabama, Kentucky, Nebraska, Montana. However, I'm not necessarily advocating that we pass the bill as it is written right now. There are a number of factors that can influence this. And so I anticipate questions as it's written right now would be things like, well, what defines a journalist? Or what if there's a particular type of court scenario where you have to get a certain piece of information endangering public liberty or public safety or whatever, something like that. And the reason I submitted this is because my goal here is to have some protection for journalists. My goal wasn't to dive into the weeds on and try to advocate for particular definitions. So many states, and my intention is to send this information to your committee right after this hearing. with the hope that one or more committee members will reach out to me and be willing to work with me on an amendment that suits the needs of this particular committee. But for example, many states like Florida and Georgia put a definition on the word journalist that journalist has to be paid. I didn't want to have the argument of, well, if it's a paid journalist, are we then disenfranchising, say, people who blog or are doing their own independent thing? Are we giving more preference to mainstream media? These are questions that I would like the Judiciary Committee to answer for themselves. They're not positions that I particularly want to advocate for or against. I just would love this committee to take this issue seriously and engage in whatever language you all deem suitable to protect reporters. And then the final thing is, why New Hampshire? New Hampshire, as far as I know, and there have been dozens and dozens of situations of reporters being jailed even for months for not disclosing sources. As far as I know, New Hampshire has no such problem. But when it comes to constitutional rights, and this is certainly falls under that in terms of freedom of the press, I am a strong believer that we put those rights out there affirmatively and not in a reactionary way, dealing with the problem after it's already happened. And certainly the framers of our Constitution felt the same. That's why they took the steps to ensure the liberties that they did. It's also why we have the Ninth Amendment. The Ninth Amendment, of course, for those of you who know, states that all of the other amendments in the Bill of Rights notwithstanding, there are other rights that we have as a people that they did not enumerate. And they went to created a whole amendment to say, and those rights are also protected. We just haven't enumerated them. So I am a proponent of being assertive when it comes to protecting our individual freedoms that are guaranteed in our Constitution. And with that, I guess I'm happy to take any questions. I just sincerely hope that this committee, I know that you all are a busy committee, but I hope that you all are willing to give it, this particular issue about journalism, the time and effort that I think it deserves. And thank you.
Are there questions for Representative Reed? I guess I think you started to address, do you consider a person who is a blogger a journalist?
Again, there would be arguments for and against, and my entire point is to strengthen protection of the journalism community and not try to define who is and isn't a journalist. I think this committee is probably well equipped to make those decisions on their own. There would be arguments that some bloggers have access or have an independent voice that mainstream media or other sources that would be able to pay professionally a journalist might not have. So there's a good argument to protect bloggers, but then where do you draw the line? Anybody can call themselves a blogger. So those types of questions, I would love if this committee, even in a subcommittee or work group, if you all could decide what you all think is the most appropriate, so long as we are recognizing that the journalism community does in fact need protection.
Representative Birch, did you have a question?
Yes, and thank you, Representative, for taking my question. I'm not sure quite how to phrase it because when I read your bill, it seemed so broad and didn't take into account the balancing that courts do when they issue delicate subpoenas like this. And I gather from your testimony, you're saying you have a good idea here in your opinion, and you'd like the Judiciary Committee to come up with a answer. Is that basically what you're saying?
Well, I don't expect the committee to start from whole cloth. I am about to send you the email. I didn't want to getting lost before the hearing, but send you an email now that you know it's coming with specific language examples in other states that various other states, both conservative and liberal leaning states, that kind of narrow this down. What I'm asking is that the committee take it seriously enough to decide from those options, which of those options or a combination of those options is most appropriate in New Hampshire.
Have a follow-up?
No further questions.
If I could make a suggestion, Representative Reed, you indicated we're a busy committee, and we are, and we're running out of time in terms of reporting out our bills. And we already have a very busy agenda, and I certainly, in terms of amending your bill to make it workable, I don't think that's something that could happen in the time frame that we have. Our only alternative would be to hold on to the bill and do some work later if the committee elected to do that. I guess so my suggestion to you is, if you think that there are changes that ought to be made, I think you should probably be the one forming that amendment instead of asking the committee to do that for you.
I understand completely, and my goal was not to kind of off-put work onto the committee. I just understood that perhaps I didn't want to assert whatever, relatively arbitrary definitions that I might come up with over what the committee would want. So I'm happy to come up with an amendment and that kind of reflects the average for the country, the various states. Again, as I said, 40 states have some sort of protection. And submit that to you all with the understanding that I'm saying right now, it's not that I'm married to these particular ideas, but if doing that work ahead of time before you've had that discussion helps you all, that's fine. Also, if the committee decides that because of time you cannot have those discussions before crossover, then I would ask that you retain it and look into it seriously when you have more time.
And yes, Representative Simpson, do you have a question?
I do. Thank you, Mr. Chair. Thank you, Representative Reed, for taking my question. Some of the things that you're talking about make me think that the Press Association here in New Hampshire might be a good resource for you in these, if you are going to think about an amendment on your own. And I wondered if you have a sense of whether they're open to that kind of conversation or resourcing or support.
Indeed, it was actually, and this is a conversation in the hall of the LOB some 3 years ago with a member of the Press Association that sparked my putting this in. I have since, this is going to be a little bit maybe too honest, I have desperately looked for this man's business card and I cannot remember who he is and I cannot seem to hunt him down. So I don't know how to get a hold of him, but I have welcomed a number of journalism associations to participate with me. Obviously, if they are doing other things and prioritizing other things, then that can't be helped. But I do welcome the New Hampshire Journalism Association as well as other organizations to work with me on that.
Do you have a follow-up question, Representative Simpson?
I do, if you may. I think my question then is that I'm just wondering if you know if it's pressing for them as a group, or if they, and not that you presume to know what they what they think, but I guess I've had my own curiosity about how the federal law operates here, and wondering if you know how important it is for them to have this in New Hampshire. That's key.
Yes, there is no federal shield law, despite different journalism associations very repeatedly and very vociferously advocating for it. It is something that just has not happened yet on the federal level, despite happening on the state level in most of the country. I don't think the New Hampshire Association finds it a particularly pressing issue in New Hampshire for the reasons I already said. We don't apparently have a particular problem with journalists being jailed. However, as I said in my testimony, when it comes to these types of individual freedoms that are guaranteed in the Constitution, I believe in taking an affirmative stance and not waiting for whatever powers that may be come into power and then abuse that authority. I believe in having those democratic safeguards in place to begin with, as did the framers of the U.S. Constitution.
Thank you. That's really helpful for me. Thanks.
Any other questions? Seeing none, thank you for your testimony today.
Thank you very much, Mr. Chair.
We have one other person who has their hand up. That's Ellen R.
That would be me. I just lowered
okay.
my hand, but I do believe there is a representative from a press association here who wanted to testify.
And there's a Malin Fiddler.
Yes, that's,
Bonus-
hear me?
Yes, we can.
Good morning, and thank you for the opportunity to speak today on House Bill 453. My name is Malin Fiddler, and I am a legal.
Hello.
Hi, sorry, it looks like I got muted there. Did you hear anything I said?
Just your very beginning in your introduction, that was all.
So just to back up a little bit, I'm here for the Reporters Committee for Freedom of the Press. The Reporters Committee was founded by leading journalists and media lawyers in 1970, when the nation's news media faced an unprecedented wave of government subpoenas forcing reporters to name confidential sources. Today, its attorneys provide pro bono legal representation, amicus support, and other legal resources to protect First Amendment freedoms and the news gathering rights of journalists across the country. The Reporters Committee supports SHIELD laws as very important protections for reporters. As Representative Reed mentioned, states have long recognized the importance of protecting reporters through SHIELD laws. Today, 39 states and the District of Columbia do have SHIELD laws in place. SHIELD laws are important because reporters necessarily rely on confidential communications with sources to report the news for public benefit. Compelling journalists to divulge confidential or even non-confidential communications with sources chills news gathering and deprives the public of important information. In particular, some of the most important stories have relied on confidential sources, from the classic example of Watergate to reporting on the War on Terror to revealing unlawful surveillance practices. And at the local level, to give a recent example, a lot of reporting on COVID-19, which was crucial to getting accurate information to the public so they could adequately protect themselves, would not have been possible without healthcare entities being able to speak confidentially to trusted members of the media. Furthermore, compelling journalists to disclose this information to assist law enforcement increases the likelihood that members of the public will perceive the press as an extension of law enforcement rather than as a neutral observer. Last, a single legal demand affects not just the work of the targeted journalist, but all other journalists whose sources will hesitate and hold back information on significant matters of public concern if courts take up the invitation to scrutinize a reporter's news gathering process. In conclusion, the Reporters Committee supports the passage of this bill.
Thank you. Are there questions for Ms. Fiddler? Seeing none. Oh, Representative Simpson.
Sorry, thank you. This is not an area of expertise for me, so my apologies. But I have a question. If 39 states is a lot of states, and so I was just wondering if in those states these SHIELD laws arose out of particular cases, or if or out of I don't know if fear is the right word, but for not being able to do the job properly.
That's a good question, Representative Simpson. I believe it probably was a mixture. I'm not familiar sort of with the genesis of the laws in every one of these states, but certainly a mixture of principle and real danger. And I should underscore, it's not just a fear of journalists being jailed that motivates these laws. The mere fact of a subpoena can have a pretty significant chilling effect itself.
Representative Birch.
Thank you, Mr. Chair, and thank you, Ms. Fiddler, or Attorney Fiddler, for taking my question. I want to be sure about your position. Are you saying that you and/or your organization supports this bill as it is written in its present form? Or are you saying you support the concept of the bill and depending on how it might be amended?
Thank you for that question. We do support the bill in its current form. As Representative Reed mentioned, there are, I believe, 17 states who have similarly broad protections, and it's been found to be fairly workable. So in terms of the definition of journalist, we think strong subpoena protections should apply to anyone who's engaged in legitimate news gathering. So from our perspective, this bill doesn't need to be amended. There are ways that you could amend it, and we would still support it as well.
Thank you.
I guess if I could just follow up on that, you know, being an attorney, I'm quite used to the idea of having attorney-client privilege, but there are certain exceptions to that. So it's not an absolute privilege. And this appears to be it's a follow-up to Representative Birch's question, really. This seems to be an absolute privilege. And I guess you've perhaps already answered the question. Is that the typical manner that these are adopted in other states, that it would be an absolute privilege, not some type of balancing, or not concerned with criminal activity, et cetera?
Yes, Representative Gordon. So the best shield laws do provide this kind of absolute privilege, and we've largely seen them to be workable. So I would recommend moving in the direction of an absolute privilege if you are able to do that.
Thank you. Are there any other questions? Seeing none, thank you for your testimony today. And is there anyone else who wishes to testify on 453? If you do wish, you need to raise your hand. And I don't see anyone else who wishes to testify. So we'll close the hearing on House Bill 453. Leave us with about 5 minutes before our next hearing. I note that on House Bill 453, there were 8 people who signed up in support of the bill and 3 people who signed up in opposition. For your information, on House Bill 133, there were 52 people who signed up in support and 11 in opposition. The next bill that we'll be hearing is House Bill 584, which I'll call to order at exactly 10 o'clock. But just in anticipation of that, just to let you know that there were 13 people who signed up in opposition to House Bill 584, and there were 0 people who pre-registered in support. Well, I'll call the hearing in order on House Bill 584. A ban relative to guilt by association and defamation by media outlets. The primary sponsor of this bill is Representative Baldessaro. And is Representative Baldessaro available to testify this morning? I do not see him on my list of attendees. Wallace, is Representative Wallace available to testify? Is there someone who would like to introduce the bill?
Well, I'm
Representative Horgan?
okay. Well, first of all, I just wanted to say that I'm here. I'm home in my office alone, and I'm not necessarily authorized anything the bill says, but I'm here to introduce HB 584, relative to guilt and association and defamation by media outlets. And it appears something to require media outlets here in New Hampshire to publish extensive updates on criminal cases and other controversies that they report on. So that's my understanding of the bill as I read it. So I guess I'll do the traditional thing and take any questions, although I would probably be unable to answer any of them. So that's it. And as I said, I've also like formally acknowledged that I'm here, home alone in my office, et cetera, et cetera. So thank you.
Well, welcome and thank you for your introduction.
Thank you.
There are people who did sign up to testify, including Brendan McQuaid. And McQuaid, would you like to testify?
Yes, hello, good morning.
Good morning.
I hope everyone can hear me.
We can.
Yes, my name is Brendan McQuaid. I'm president and publisher of the New Hampshire Union Leader. I am here on behalf of the New Hampshire Press Association, and we strongly oppose this bill. As I think anyone who actually reads the text of this bill would see, this bill is patently unconstitutional. The idea that you can force media companies to print something has long been struck down in the history of this country and is anathema to both the First Amendment to the Constitution of the United States as well as to the New Hampshire Constitution. I would strongly suggest that members take a look at the provenance of this bill. This seems to be an activist bill that has been introduced both in Mississippi and in Rhode Island, and very quickly either voted down or actually withdrawn in both those places because of its very nature. There seems to be a guy who is quite against the media and has tried to introduce this to punish the media for their transgressions against him. Anyway, the bill being unconstitutional sort of stands by itself. I will talk briefly about what I think people who see a bill like this would tend to understand as the reasoning behind it. And it's a very real concern for people that are accused of crimes, that they have an accusation against them. It becomes a matter of public record. The accusation goes out there, the arrest record goes out there, and for many people that is the end of it, because a lot of these things end in, pre-trial. They don't actually follow through. So we as the press don't get any follow-up information on these things unless we're notified about it. And the union leader, as well as all professional presses, members, have a process that we go through. Anytime we're contacted by someone who is affected by this type of thing, we actually will take a look at what they submit to us, and we will decide whether there's an update or a correction that should happen. Sometimes there's a full-blown story that follows up to actually explain the outcome of a case. We're happy to listen to any suggestions that folks may have about that process, about how we could do it better. I would strongly urge you to not consider this bill as a solution to that problem. Just read the bill. It is completely outrageous the way that it demands within 10 days that a publication change what it has previously published. The $10,000 fines that it attempts to impose, as well as further damages beyond that. The chilling effect, especially on smaller outlets, would be substantial. Let's see. Sorry, just trying to go through my notes, make sure that I've covered everything. The main concern here, and I think it's important for the members to realize this, we had a similar bill that came up last year. The problem here is not the local media. The local media is who's going to be affected by this bill, but the problem is Google, and that's the thing that everyone is frustrated by. And that's what we hear most often is people call us and they say, I Googled my name and your story about me came up. Unfortunately, that's a Google problem more than it's an us problem. I mean, we've kept archives for years. We didn't go back into the microfilm and white out the stuff that, changed. Google makes it so easy to delve back into these records that it really does become a problem for people that their digital life, when you look at Google, often becomes their most prominent thing, which sometimes is an arrest that does not look very favorable upon them. So that's why we do everything we can to update, to put the disposition of a case if we have appropriate records for that, so that people have a full understanding of the picture. But again, this is not the way to do it. If you look at it, it actually says that we can no longer run the mugshot if we have a mugshot of the person, if there's a further disposition of the case. Well, sometimes the mugshot is the story. We had a case in Manchester where the guy's mugshot actually showed that he was roughed up by some folks during the course of an arrest, and that became the story. If we could no longer run that mugshot, it would just be ridiculous. We wouldn't be able to tell that story anymore. So I urge the members to consider this bill inexpedient to legislate as it is. And I hope you will listen to the further folks. I think there are probably some legal experts who can give you some more of the background on the history and the legality of bills such as this, but I'm happy to answer any questions as it relates to the press.
Are there questions for Mr. McQuaid? Yes, Representative Simpson.
Hi, thank you. I think this is a simple question I just don't know the answer to. When you rerun a follow-up, if there is one to rerun, do you rerun the mugshot with it, or do you have another picture that you rerun with it, saying that maybe a person was found not guilty or something like this? Do you rerun the mugshot or seek to find a different picture that's not?
So it depends on the story. Usually we will update the story as it exists. So the story is a snapshot in time, right? Newspapers are often considered the first draft of history, and that's where we like to keep it. So we will actually update that same story. So if there was a mugshot with that story, it will often stay with that original story with a header or an update on the story to let people know that there actually has been a disposition to the case. But if there's a trial that we're following, that we're actually allowed to be in the courtroom, yeah, we'll usually run a picture from that because that's an update on the story.
Senator Chase.
Thank you very much, Mr. Chair, and thank you for taking my question, Brendan. When something is done incorrectly, a story isn't written correctly or more information comes forward, and I know that a lot of media will just put in a little blurb saying in last week's column so-and-so was said and this was not correct. When that's done, is it attached, I'll say online or in some type of a media situation, to the original articles so that also comes up immediately when somebody searches? Would that help with this?
So online, yes, that those corrections tend to get made to the online story. That's the way that that works. In print, you actually, it's just a practical matter. You don't want to repeat the mistake in a correction. So you actually print what the factual information should have been. You don't repeat the same mistake. So you would cause further confusion to the reader.
Thank you very much.
Any other questions for Mr. McQuaid? Seeing none, thank you for your testimony today.
Thank you all very much.
Gregory Sullivan.
Sorry about that. I had to unmute myself. Good morning, Mr. Chairman, members of the committee. Thank you for allowing me to testify. My name is Gregory Sullivan. I'm an attorney. I represent Union Leader Corporation and the New England First Amendment Coalition. As Mr. McQuaid just testified, this bill is blatantly unconstitutional. It's black letter law in the United States. And I'll talk quickly about the case of Miami Herald versus Ornillo. And I'm going to just give 3 quotes from that case, which was the Supreme Court of the United States in 1974. It says, dictating what a newspaper must print is no different from dictating what it must not print. Press responsibility cannot be mandated by legislation. And thirdly, there can be no intrusion into the function of editors. I mean, that's the law. And this bill lies directly in the face of that law, clearly. I'd point out it's not just criminal cases that this bill addresses either, it's civil cases. So under this bill, if someone sues for $1 million and they get $1 or they get 999,000, whatever it is, the newspaper is mandated to run a follow-up story. And not only is it unconstitutional, it's completely impracticable for the press to be able to track every single civil, criminal, administrative case that happens in the state. In the law, we have a phrase, void for vagueness. There are so many provisions of this bill that would be subject to anyone's differing interpretation that it clearly is void for vagueness. So I'm not going to take up too much of your time, but I will point out that Part 1, Article 22 of the New Hampshire Constitution is even stronger in its protection of the free press than the First Amendment is. It says that the free press and free speech are essential to the security of freedom in the state and therefore must be inviolably preserved. Well, this bill does not in any way inviolably preserve the freedom of the press. It does just the opposite. And I'll be glad to answer any questions. I'll state, as Mr. McQuaid did, now I've been representing the union leader for over 40 years, something I'm hesitant to admit. But there was no Google back in the day. And from then to now, Union Leader has done everything it possibly can, and many other professional publications are the same way, to rectify errors. Because as the bannerhead of the Union Leader says, there's nothing so powerful as truth. And that is indeed what the Union Leader seeks to publish day in and day out, and now even on unionleader.com. And the New England First Amendment Coalition, I'll mention, is a group of attorneys, editors, journalists, and concerned citizens in the 6 New England states. And its executive committee has instructed me to speak as vehemently as I can in opposition to this bill and ask you to deem it inexpedient to legislate. Be glad to answer any questions you may have.
Thank you, Attorney Sullivan. Representative Di Lorenzo.
Thank you, Mr. Chair, and thank you, Mr. Sullivan, for taking my question. So in your opinion, would you say that this bill has no redeeming merit?
You know, I think the motivation behind the bill is understandable. I've represented clients who felt that they were unfairly treated by the press. But what I've done is call the editor or publisher of the newspaper, not the local state representative. So I think the motivation, as Brenda McQuaid said, is understandable. There are problems that occur, but it's up to the press to take care of those problems as best they can. And the press that I'm familiar with do it every day.
Thank you. May I follow up?
You may.
So have you, Mr. Sullivan, have you heard of any other states that are trying to project this legislation?
Only the two that Mr. McQuaid mentioned, which were immediately knocked down. There's similar legal concepts, for example, the right to reply for a political candidate. And those efforts to mandate the press giving equal time to various candidates have been stricken for the same reasons we've discussed and were dealt with in the Miami Herald case back in 1974.
Thank you very much.
You're welcome.
Any other questions for Attorney Sullivan? Seeing none, thank you for your testimony today.
Thank you very much.
Those are the only people who pre-registered to testify. Is there anyone else in attendance today who would like to testify on House Bill 584? I see no one with a hand raised, so I will close the hearing on House Bill 584. And we're not scheduled to have, I misjudged the amount of time I thought this might take. So we're not scheduled to have another hearing until 11 o'clock. So I think the best thing to do is to recess until 11 o'clock, and we do have a bill at that time, which will have a number of speakers and sponsored by one of our committee mates. Okay, we'll see you at 11. Oh, excuse me, Representative Smith.
Thank you very much, Mr. Chair. First of all, I think you owe no one an apology for trying to guess in advance the amount of time you need for each bill. This is not an exact science, and you've done very well. My other point is, I gasped when I saw the Tuesday schedule and the number of bills that we have to exec, and worry about the proverbial throwing out of the baby with the bathwater if we don't really have time to focus on the bills where we can make a significant contribution. So my question is, are there any bills now that you feel comfortable enough with to perhaps have us exec? And I'm not second guessing you. I don't even know if there are any. I'm just raising it as a possibility since we have 45 minutes.
How about this one?
Unfortunately, there are, first of all, it's unfortunate that we have to meet on Fridays at all, but it's just our schedule has brought us to a point where we need to do that with the number of bills that we have. But there are people who just can't make it because they have conflicts on Friday. And that's why I put the exec session on Tuesday when I think people ordinarily would expect to be here. So, but I've told people since they can't be here, I'm not going to exec bills. And so I really don't feel I can do that.
Thank you very much.
But what I am hoping, and what I was anticipating telling everybody is, what I hope people will do is go through the bills in anticipation of Tuesday with the idea that they have an understanding of what they would like to exec. And I certainly am going to do that in advance and try to provide as much leadership as I can, because there are some bills, perhaps even the last bill that we heard, that might be obvious in terms of an outcome, and try to get those addressed and get them done quickly. And go through as many bills as we can, but I'm with you. I don't want to rush through bills and produce a bad product, because that serves nobody's interest, I think. So we'll do as much as we can on Tuesday. And,
Thank you, Mr. Chair.
and then we'll do, if we have to carry stuff over to the following week till the 10th, then we'll do that. But we need to get everything done on the 10th. You know, if we can't get it done on the 10th, we could always recess and do it on the 11th. But everything has to be out on the 11th, and I'd rather get it done on the 10th so we can get the reports done and get everything taken care of. Then is Sylvia.
Thank you, Mr. Chair. I have a question regarding procedures. At 1 o'clock, we have HB 440, for which I have an amendment, essentially replacing the bill. As far as if we were in committee, ordinarily, if I were a co-sponsor on a bill, I would not be able to ask questions. What would be my situation as the sponsor of the amendment, which essentially is becoming the bill?
It's becoming the bill. I would think that you would testify, but then not participate in the question and answer portion.
Okay, great. Appreciate it.
Representative Horgan.
Well, first of all, I apologize for being late. I had the Stratford County Executive Committee, and actually an issue, am I muted? And an issue that came up there, we were going to have the full delegation meet on town meeting day, which is the 10th. So that we'll be meeting in the morning or the afternoon on the 10th, but that's a scheduling factor to consider. Just thought I'd bring up those 2 points. As for 440, I guess technically the amendment doesn't become the bill until we accept it in executive session, which may or may not happen. But I thank Representative Sylvia for expressing his concern. So that's what I had to say. So
I think
I
town
came in as
meeting.
soon as I could. Yeah.
I think town meeting day is the 9th, if I'm not, Tuesday the 9th.
Okay, maybe. Oh, I know. Maybe that may have arose. Okay, you're right. Of course, I'm sorry. I think that arose because one of the members of one of our towns is having rescheduled their deliberative session for the 10th. Or anyway, my apologies. So
that's not a problem. We ordinarily would meet on the 9th, but because this time meeting day we can't meet as a committee, so that's why we're scheduled to meet on the 10th.
Oh, perfect. Yes, that makes sense.
Representative Sylvia, did you have another question?
No, I was trying to figure out how to put my hand down in the
no.
I am now home in Belmont, so I'm going to go back to my regular device.
Thank you. Okay, and Representative Birch.
You're muted, Paul.
Yeah.
Oh.
Just to note that in Westmoreland, we do our voting for town meeting on the 10th.
You do your voting for town meeting on the 10th?
Yeah.
If I can just ask, how does that happen?
That's we normally do it on that Wednesday, and this is going to be by drive-through, so I'm not even sure how it's going to work. But we'll figure something out.
Sorry. Anything else? Then we'll recess and reconvene at 11 o'clock.
Thank you, Mr. Chair.
Thank you, everybody.
This thing is compared.
Morning again, everyone. We'll call this meeting to the House Judiciary Committee back to order. Our next item of business today is a hearing on House Bill 540. I'd note that prior to the hearing, 59 people signed up in support of the bill and 0 people signed up in opposition to the bill, and 2 people signed up as neutral to the bill. There are 8 people who pre-registered to testify today. House Bill 540 is relative to supported decision-making as an alternative to guardianship. The primary sponsor of that bill is our own Representative Chase. And Representative Chase, I'll call upon you to introduce your legislation.
Thank you very much, Mr. Chairman and members of the Judiciary Committee. My name is Wendy Chase. I am a New Hampshire State Rep for Stratford County District 18, and I'm also a member of this respected committee. HB 540 would create an alternative to guardianship for adults with disabilities and their families who wish to establish a way of providing support without taking away self-determination. Under the current law, there are very few options when a family is looking for a way to provide support to their loved ones with a disability. This issue often comes up when a young person is about to turn 18 and the family wants to continue supportive role in the areas like education, health, care, and public funded services. But right now, there are no recognized meaningful alternatives to guardianship, which involves the removal of decision-making powers from the person, and it gives it to the guardian appointed by the court. The power of attorney can be used for financial and health care decisions, but these alternatives typically involved the full takeover of the decision for someone, and they are often only available when someone becomes completely unable to make a decision for themselves. 540 would create a legal recognized alternative so that people in a range of circumstances can be provided the support they need without the court removing their freedom of choice when this is unnecessary to meet their needs. People with disabilities often simply need what we all utilize from time to time. We need support at various stages of our life in various subject areas. Most of you on the committee may look for help in understanding important complex information when making important financial decisions, for example, or you might seek advice from trusted friends and relatives when facing challenges or momentous decisions involving your health. This bill recognizes the reality and it makes that kind of support formally available for adults with disabilities. The bill will not disturb the availability of guardianship for the people who need for sometimes to have people make their own decisions for them. If this bill was to become law, the standard for creating a guardianship would still remain the same as it is today. The bill merely creates an alternative for those common circumstances where support is needed, but no removal of self-determination is. And just a little notice to why I am supporting this bill so wholeheartedly is because I did become the legal guardian for my beloved daughter, Erin, at the age of 27 until she passed away at the age of 34 in 2018. Erin became physically disabled at age 3 when she developed a rare childhood cancer that left her with many unknown and known medical issues. The side effects from the treatment also left her reasoning and her emotional levels a bit immature, which does happen. And in certain situations, it caused her to think with her huge, big heart and not always with her head. I sought guardianship due to her many trips to the emergency room where I was no longer able to have a voice. I couldn't help make decisions in her care, and sometimes I was not even able to stay in the room during a consult. Usually I was met with that same social worker who told me over and over that I needed to get full guardianship to legally continue to be part of her care. So I did, and it wasn't what either of us had expected. And it tended to drive a stake between our loving relationship. She felt she lost so much of her independence and her self-worth. And I just wanted to be her mom. I didn't want to have to control her life. If supported decision-making had been an option as an alternative to the guardianship, I can't even begin to tell you what a difference that would have made in my daughter's life, my life, and most of all, our relationship. I want to thank you once again for the opportunity to bring HB 540 before you today. I hope you will listen well, read the testimonies from New Hampshire residents where this legislation could make a very positive impact on their lives or the life of someone they dearly love. And next, Mike Skibby, the director from the DRC, will be testifying after me, and he can respond to your questions about technical aspects of this current law. And again, I thank you very much for this opportunity.
Thank you, Representative Chase. Are there questions for Representative Chase? Seeing none, thank you very much.
Oh, I'm so sorry.
There.
I'm sorry. Chair Gordon, I did also send an unapproved amendment for this, which I think you all should have received. And Mike can also talk about that if needed. Thanks.
Yeah, that would be helpful.
If you don't have it, I can resend it.
Okay. We do have some other co-sponsors who wish to testify, and I'll call upon them first, and then we'll get to Mr. Skibby. And Representative Weber has requested to testify.
Thank you, Mr. Chairman. Thank you, members of the committee. My name is Lucy Weber. I represent Cheshire 1, which is the Connecticut River towns of Hinsdale, Chesterfield, Westmoreland, and my own town of Walpole. And one of my past lives, I was an attorney starting in wills, trusts, and probate, and then with a focus on what was then in the emerging field of elder law. Now I'm just an elder, but I cannot tell you how much as an attorney I would have valued having this kind of a process available for just the sorts of people that Representative Chase described, and let me offer my sympathies on the loss of her beloved daughter. Allowing people their autonomy is a crucial point of all of our lives, and allowing people to make their own decisions as best they can. A lot of what's in the bill is simply a matter of contract, and why not just have contracts? Well, a lot of what's in the bill helps with things like getting access to information that holders of that information, like the IRS and other organizations, don't want to release because they don't want to invade people's privacy, but a decision helper might need access to them. And I also like the fact that there is a slight reference also to the ability to refer to DHHS, which of course is already in statute, to Adult Protective Services if somebody encounters a supporter that is not making decisions in the best interests of the ward. The addition of the fiduciary duties that are incorporated into this bill and the fiduciary standards are really necessary. And I think it's a great concept. I thoroughly support it, and I look forward to hearing Mr. Skibby talk about it more. But with that, I will end my testimony.
Thank you very much. Are there any questions for Representative Weber? Seeing none, thank you.
Thank you, Mr. Chairman. Thank you.
And I think Senator Whitley would like to testify as well.
Thank you, Mr. Chair, and good morning, members of the committee. For the record, my name is Becky Whitley, and I'm honored to serve New Hampshire Senate District 15, which includes the communities of Concord, Pennacook, Henniker, Hopkinton, and Warner. I am proud to co-sponsor and testify in support of HB 540. And today I'd like to share my personal experience with supported decision-making as an alternative to guardianship. My sister-in-law, who lives in a different state, experiences a developmental disability with significant cognitive impairments. She is also kind, incredibly perceptive, loves animals, plants, and people, and is an incredible part of our family. She is 39 years old and lives an incredibly full life also. Before COVID, she lived on her own and filled her days with work, friends, and play practice. She has lived a very full life for many years without the assistance of a guardian, but instead through the strong support of friends, family, support professionals, and through formal and informal supported decision-making. For generations, people with intellectual and developmental disabilities have been overprotected, over-controlled, isolated, segregated, and excluded from our communities, and were often forced to live in places removed from the lives and experiences that people without disabilities take for granted. This kind of segregation and overprotection has led to a constrained life with a loss of power, autonomy, and other rights for so many people with disabilities. We have long classified and categorized individuals who experience a disability rather than supporting them as important and contributing members of our society. Guardianship has long been the primary vehicle to so-called protect people experiencing a disability from making bad or wrong decisions about their lives and resources. However, awarding guardianship over a person can often result in significant removal of basic rights that should not be taken lightly. It can often result in people experiencing a disability being treated as if they were less than and incapable of managing their own lives, including the most basic of life's choices. People under full guardianship have no right to make their own decisions about their health care, their finances, their relationships, and other day-to-day decisions. People under guardianship are often less likely to live in their own homes or apartments, less likely to have jobs in the community, and less likely to have friends. This supported decision-making model gives individuals experiencing a disability, like my sister-in-law, a voice and helps them make their own decisions. We all rely on others to help make decisions in our lives, and people with disabilities may need more or just different type of help. No one should be kept from making decisions about their life because of the type of support they need. Thank you so much for allowing me to testify, and I'm happy to take any questions.
Are there any questions for the senator? Seeing none, thank you for your testimony today.
Thank you.
Okay, we have a number of other people who have signed up to speak today. But I think Representative Chase, you asked that you could have Mr. Skibby speak, so we'll have him speak next.
Good morning. My name is Michael Skibby. I'm the Policy Director at the Disability Rights Center of New Hampshire. I'm here to testify in support of House Bill 540. I want to thank Representative Chase for her prime sponsorship of this bill and for sharing her story. It's been a powerful experience for me to hear about her experience with her daughter. And I've had a similar experience talking to several of the co-sponsors, including Senator Whitley. It's one of the great things about my job to talk to representatives who frequently have the kinds of experiences that my office is really focused on a day-to-day basis. So thank you to you, Representative Chase, and to the other co-sponsors, including Representatives Birch, Langley, and you, Mr. Chairman. This bill is a result of a collaborative effort over the better part of the last year with input from lawyers who work in the field, national experts, and a drafting work group, which included members of organizations such as New Hampshire Legal Assistance, ABLE New Hampshire Family Voices, an area agency, and Granite State Independent Living. Supported decision-making has received significant attention nationally in recent years. In the last 5 years, 10 states have adopted statutes like House Bill 540 would adopt. In addition, national organizations such as the American Bar Association, the National Guardianship Association have made policy statements in support of the establishment of supported decision-making as an alternative in appropriate cases to guardianship. There have also been initiatives that have been funded by the Federal Department of Health and Human Services to explore and develop supported decision-making in the various states. I think to appreciate the value of this bill, it's important to understand the basics of guardianship. It's the complete removal of decision-making and choice by the court and the granting of that authority to an appointed guardian. Now, the court may tailor and limit its order of guardianship, but only in the sense of the subject areas that it covers. That is, if a guardianship is imposed with regard to financial decision-making, for example, or housing, decisions in that area are no longer controlled to any degree by the person with the disability. They are controlled completely by the guardian. Commonly, guardianship is granted in broad areas, including providing for things as basic as food and clothing and shelter, but also healthcare and safety and management of property and financial affairs. When it is broadly imposed, it's very similar to the complete responsibility and authority that a parent has over a minor child. Now, this is an important legal option to have available if someone is truly incapable of making decisions on their own behalf to any degree. This bill would not remove it as an option for those who are truly in need of that level of intervention. What this bill would do, however, is create a legally recognized alternative to guardianship that recognizes that many people with or without disabilities need support and advice when making important decisions, but often only need support and advice, not removal of their freedom to make their own choices. I suspect that, like me, all of you turn to trusted professionals or friends and family for advice about important decisions. It may be to help with understanding certain unfamiliar information, or helping to recognize and weigh the pros and cons of certain alternatives. That is essentially what is meant by supported decision-making, and it works for people with disabilities in much the same way as anyone else. People with disabilities who might otherwise be considered candidates for guardianship are frequently able to manage the choices and decisions in their life so long as they have the support and advice that they need. Now, support may mean something like modifying the language used about a certain subject, or helping to gather information that would be helpful, or having a supporter present during meetings with doctors or other service providers. This is a good example, I think, in a lot of our lives. In my own case, as my mother was at the end of her life, my siblings and I would attend doctor's appointments with her. Not because she was unable to continue to make her own decisions, but because it was helpful to have one of us there to help frame the conversation in a way that allowed her to understand and to assess the pros and cons of her choices. And with our support, the choices continued to be her choices, not someone else's, made on her behalf. They were not always the choices that we would have wanted for her, but they were her choices. And that was an important component of her quality of life at the end of her life. Now, House Bill 540 essentially recognizes the reality that many of us can retain our freedom of choice so long as we have the support we need. It probably goes without saying that if anyone is able to retain their freedom of choice, they should be permitted to do so. What may not be so obvious is that the maintenance of self-determination has significant benefits for an adult with disabilities beyond that. As the parent of an adult using supported decision-making recently told me, decision-making is a learned skill, and as it is learned, other things come along with it. People who maintain their self-determination have been shown to be more independent, healthier, both physically and psychologically, and better able to recognize and resist abuse and exploitation. They also tend to be more integrated in their communities. That is, they're more likely to live and work with others who are not also people with disabilities. Now, the bill is summarized in some detail in my written testimony, but let me just briefly explain that the first few sections make changes to existing law to help facilitate implementation of supported decision-making and of the new statute that is created by the bill. Sections 2 and 3 of the bill make minor changes to the guardianship statute to identify the availability of supported decision-making as one of the things that a court can consider in determining whether guardianship is the only way to support and protect a person with disability, and also as a basis for concluding that a particular guardianship is no longer needed. Section 4 deals with special education law, and it deals with the specific issue of transition of a special education student. This is an area of current responsibility of special education staff to help prepare a child with a disability for adult life after schooling is completed. Sometimes this includes discussions of whether guardianship should be pursued by a family upon a child turning 18. Now, families often pursue guardianship because they do not know of alternative ways to remain involved in their child's life into early adulthood. And once guardianship is in place, it is very uncommon for it to be undone. What the bill would do would direct that special educators include information about the supported decision-making alternative if they have discussions with a family about pursuing guardianship. It does not require that such a discussion occur, but it does require that if a guardianship discussion occurs, that it include the alternative of supported decision-making. That section of the bill further directs that the Department of Education prepare information to be used in such discussions so that local school districts are not required to prepare their own materials. The remainder of the bill sets up the new chapter establishing supported decision-making as a formal alternative to guardianship. I won't go through it line by line, but I just want to point out some of the, I think, key components of the new statute. On page 4, line 23, it lays out the necessary components of a adequate supported decision-making agreement. It requires that there be at least one supporter, a description of the subject matter, a description of any subject matter that is excluded from the arrangement, how it has to be written and dated and witnessed, so forth. On page 6, starting at line 16, it describes the fiduciary relationship that supporters need to have to their principal and how their authority is limited to what is given to them in the agreement. On page 7, starting at line 10, it talks about who may not be supporters, including employers or employees of the principal, people who are paid to provide services to the principal, or people who've been convicted of certain offenses or against whom orders of protection have issued. On line 34 of that same page, page 7, it describes the obligation to make a report of abuse if persons who are aware of abuse or exploitation by a supporter, if a person becomes aware of such abuse or exploitation by a supporter. I think that in conclusion, I just wanted to point out that New Hampshire uses guardianship actually more than the average state. I looked at some data from about 4 years ago from a survey of adults with intellectual and developmental disabilities who receive state agency services in the various states. Now, among that group, the guardianship rate nationally was 56%. 56% of those people surveyed around the country had guardians. In New Hampshire, it was 76%, 3/4, 20% higher rate than the national rate. So that could mean a lot of things, but I think it's a probably pretty strong indication that we may have people under guardianship in this state that could be successful using other models of support. And so it makes sense for us to make sure that people have a range of alternatives. And House Bill 540 would be a strong step in that direction without diminishing the availability of guardianship for people who need that level of structure and substituted decision-making. Thank you for your attention. I'd be happy to answer any questions.
Thank you. Representative Page.
Thank you. Thank you, Mr. Chairman. And thank you for taking my question, Attorney Skibby. I have a question. I read that the New Hampshire School Special Ed Administrators Association had some questions. I believe they supported the bill. I don't want to misstate what they wrote in their letter, but that's my recollection. And it looks like there's an amendment to that, I think, provided by Representative Chase. Does that address their concerns? Because in their memo, they had noted they would be talking with you. So I wanted to see if you feel like that amendment has been a compromise. And then the second part, if I may, is whether if you could, if you could just sort of describe what the sharing of that information would look like, so that it would be a meaningful sharing at the IEP table.
I think, thank you, Representative Page. And I probably should have spent a few moments on the amendment that Representative Chase is going to be bringing forward. To take the last part first, I think probably helpful to think about how this responsibility put on special educators would be fulfilled. And what we have in mind is the development of a fairly simple piece of written information, like a pamphlet, that would be developed by the Department of Education, that would be available to an IEP team, that is the group of special educators that work with the family, to hand over to the family as they begin this discussion of possible guardianship, if they choose to have that discussion, so that their responsibility would be fulfilled by simply passing along the information that had been developed by the Department of Education. And I think the Department of Education is directed to basically consult with organizations like my own and many of the other disability rights organizations in the state to develop a relatively straightforward explanation of the supported decision-making alternative. Now, the amendment itself makes some, I won't call them stylistic decisions, changes, but some modifications to the language of Section 4 of the bill that came as a result of a discussion I had with the Special Ed Administrators Association. It would make clear that the obligation would only arise if there is an actual discussion of guardianship with a family, not if it's simply being considered, which is the current bill language. It also would make some changes with regard that just sort of clarifying how releases of information would have to be executed by the principal, would not be executed by a supporter. There's some additional concern that they raised, I believe, in their letter, if I recall it correctly, about what they've referred to as a hold harmless provision. I think I need to give further consideration to that and perhaps have some further discussions with them about whether that would make sense. I think the liability concerns that they may have, I don't think I share those concerns, but I think I'm willing to, and I think that Representative Chase is willing to give that some further consideration.
Thank you.
Representative Sylvia.
Thank you, Mr. Chairman, and thank you for taking my question, Mr. Skibby. And before I get to my question, I'd like to apologize. The flow of information coming through email these days is swamping us, and particularly me, I guess. And I have gotten your emails and paid attention to them, but haven't gotten back to you. So as to my question, the language in this bill is good. I like a lot of it. There is one concern that I see for these folks, and particularly the support people. There's been a lot of discussion over the last few years about statutes for vulnerable adults. And it would seem that the support persons would be possibly in an awkward position should such a statute be enacted. Do you feel that lacking that that proposed legislation, are these folks going to be protected enough by the current statutes that they won't be subject to abuse?
Thank you for the question, Representative Sylvia. So if I'm understanding your question correctly, it's getting at whether the use of a supported decision-making agreement would make an otherwise vulnerable person more vulnerable than they would be in the case of guardianship. Is that the gist of it?
Yes, it seems like there's a lot of responsibility for the support person, and
right.
is there a danger to them? Is there a reason for them to be afraid that signing up to be a sport person would be a problem for them?
Well, it's certainly something that I think anyone should consider carefully before entering into. But I think that it is a completely voluntary arrangement, and no one is compelled to be a supporter who does not wish to be. I think it's probably good to recognize that these kinds of arrangements exist today, although they may not be formally recognized. So, for example, just as you heard Senator Whitley describe, and there were other co-sponsors who described similar situations to me, where they have a family member that they basically act as a supporter, just as this statute would contemplate, but it's done in an informal, and unrecognized way. And so they've stepped forward to provide assistance, and they don't incur any liability by doing so, and I don't think any liability is incurred by this statute itself. And the statute recognizes that a supporter may decide to terminate their involvement in a supported decision-making agreement. What I do think is helpful here is that the formalizing of this as an option, it basically it draws the attention of all parties to the agreement, the principal, the person with the disability, and the potential supporter, to what it is that they're signing up for. The agreement basically identifies to the supporter that this is the obligation that you're undertaking, and it requires the supporter to acknowledge that they understand that. And I think that that's good for both parties to the agreement, so that there's no misunderstanding and potential, the potential of something dropping between the cracks, as you might have in today's, circumstances. I also think when we are thinking about vulnerability, the research shows that people who enter into these agreements or otherwise maintain their self-determination by avoiding guardianship are actually less likely to be exploited and less likely to be vulnerable. Because, as I was discussing before, when people have that self-determination, they tend to be more aware of what's going on around them and more ability to assert themselves to avoid abuse and exploitation. So I think it certainly makes the people with disabilities probably more resilient, not less resilient. And I think the formalizing of the agreement probably makes it more likely that somebody who agrees to be a supporter will go in with their eyes wide open rather than under today's regime.
Thank you.
Any other questions for Attorney Skibby? Yes, Representative Smith.
Thank you very much, Mr. Speaker. I first want to begin by sympathizing with what Representative Sylvia noted, that we are drowning in emails, in text messages, in material that we do or do not print out. And it's very hard to make sure that we're not missing any information that would help us make an informed decision. We received some written testimony from an attorney in New Hampshire whose name is Sheila Zachary. And I don't know if you have had an opportunity, I know you know her, I don't know if you've had an opportunity to discuss anything about this bill with her. But her testimony is really, I think, very interesting. She talks about what she sees as rather overbroad definitions. And for example, quotes, most people with disabilities have the ability to make decisions for themselves when they are provided the necessary information and support to do so. Ms. Zachary's interpretation of this is less than positive. She uses a very interesting, there is a question, Mr. Chair. I won't explain more about what she says, but as you read the language, particularly in the statement of findings, do you have any sense that, certainly not by intention, but by result that the language in the findings in some ways insults or diminishes the awareness of the ability of people with disabilities to make informed decisions.
Thank you for the question, Representative Smith. I don't know Attorney Zachary, but I know of her, and I know that she is a lawyer who's done work in this field for some time. I guess all I can say is that as the person who drafted that language, I don't think it communicates what Attorney Zachary takes it to communicate, but I wouldn't dispute that she honestly received it that way. And if others receive it that way, and the committee wishes to modify those findings, I think that is absolutely fine with me. And if you'd like me to participate in a process to adjust the language, I would be happy to do that. They are not definitions, so changing that language will not disturb the actual law after this bill is hopefully brought to final passage. So I would have no problem if it is the will of the committee to make adjustments to those findings so they are not offensive to anyone.
Could I follow up?
You may.
Thank you very much, Mr. Chairman. So is it safe to say, Mr. Skibby, that in your judgment, if we eliminated or severely modified the statement of findings and focused instead on the actual language of the bill for what you propose to do, that we would not be weakening the import of the bill?
That is what I mean to say, that I think that you can adjust the statement of findings significantly or even eliminate them without changing the substantive law that would be adopted by the bill.
Thank you very much, Mr. Skibby. Thank you, Mr. Chair.
Thank you. Are there any other questions for Attorney Skibby? I did have just one question quickly, and that is, what level, with most estate planning type documents, there has to be at least some level of competence in signing the document. What level of competence would a person have to have in order to enter into this agreement?
Well, I think, let me just find the section, Mr. Chairman. I think that what I would refer to is on page 5, line 4, which is basically a continuation of the previous section, which talks about the components of a valid agreement. And the standard there is that each party to the agreement has signed the agreement voluntarily and with an understanding of the nature and effect of the agreement. So I think that's the closest that the bill has to what you're getting at. If the person does not understand what it is that they're entering into, then the agreement that they enter into would not be valid. I think that there was not an attempt to try to define some threshold of capacity in the same way that other areas of law do, because I think the point is that there is a sort of dynamic relationship between the capacity and collection of strengths and weaknesses that the person with disability may have, and the type of support, the intensity of that support, the subject matter of the support, and the skills of the supporters. That if those mesh together, I think there can be a range of capacity that would work for the person with a disability, so long as they understand what they're getting into.
So, and we were talking about special education earlier, but as I read the document, it applies only to adults. Is that correct?
That's correct, because a minor does not have the sort of authority that would be taken away by guardianship. They basically are under guardianship until age 18 by virtue of their parents.
Right. And I guess the last question I have is, so I'm a doctor and somebody shows up and they have this type of an agreement. And my concern is, to what extent can I rely on the agreement? I guess all I can really do as a doc, I can't really rely on the support person based upon this, because ultimately it's the decision of the person who entered into the agreement, the principal in the agreement. And I can't really rely on what the supporter might tell me to do, like a power of attorney.
Well, I think that's right, but I think it's important to emphasize that, I mean, this makes no change in terms of the sort of legal authority. I mean, if someone is not under guardianship, then it's the patient, the adult patient, who is in the driver's seat when it comes to healthcare decisions, or, there's analogies in many other subject areas as well. And I think what this law would do would be to recognize that there are some people who need support of one type or another to be able to make informed decisions and to communicate those decisions. It may be an inadequate analogy, but I think it may be helpful, is just as someone who uses a sign language interpreter sitting in the doctor's office, the doctor may not be able to discern directly what the wishes of the principal of the patient are, but through the use of an interpreter, they are able to discern, and their responsibility to conform to the wishes of their patient remains, even though there may be a different way of communicating with the patient.
Thank you. Any other questions? Seeing none, thank you for your testimony today.
Thank you.
There are other people who wish to testify. And the Sheila Zachary. I don't know if I'm pronouncing that correctly.
I am here. I just unmuted my microphone. Can everyone hear me?
We can.
Okay, thanks. I did provide written testimony as Representative Smith stated, and I'll go through that testimony so that you get, if you didn't have the opportunity to read what I sent over to the committee, you can get the understanding, I think, of the comments that Representative Smith said. And then I don't want to take too much time, but I do want to just give you my perspective as a member of the public and as an attorney who has sat many times with families to discuss guardianship versus alternatives to guardianship, as well as sitting in special education meetings, kind of what really happens from my own experience. Good morning, and thank you for accepting my comments regarding HB 540, a bill regarding supported decision-making. My interest in this legislation is manifold. I was born with a significant visual disability in 1958, so I'm in my 60s. I have a lot of experience with this, and I've had lifelong experience with the ways in which people with disabilities are treated differently from individuals without disabilities, sometimes inadvertently or with beneficent intention. I have been an attorney for over 3 decades, which includes over a decade as a former staff attorney at the Disabilities Rights Center in Concord, New Hampshire. And currently I have a private law practice that specializes in a wide range of legal issues affecting people with disabilities and the senior population, including discrimination, estate planning in the event of future disability, and guardianship. I am also the parent of an adult with a developmental disability who is not under guardianship, who lives independently and works in Concord. And he's also a client on the developmental disabilities waiver. However, what most informs my understanding of the issues facing people with disabilities is my firsthand experience. That being said, I was put off by language in this proposed legislation. The purpose of this legislation is to provide an alternative to guardianship. I support that purpose. However, right at the outset, the statement of findings makes overbroad, inaccurate, and untrue statements about persons with disabilities generally, the group it purports to help. For example, under the statement of findings, paragraph 2 reads, quote, "Most people with disabilities have the ability to make decisions for themselves when they are provided the necessary information and support to do so." And in my written testimony, I italicized the phrase, "when they are provided the necessary information and support to do so." This perpetuates a negative and untrue view of people with disabilities as being less competent and less capable generally than people without disabilities, because of that qualifier that they can only make decisions when they are provided by someone else the necessary information and support. The flip side of this are those backhanded compliments such as "you do very well," or "I don't think of you as disabled," that have been directed to me by professionals and colleagues. And I don't think that I am alone as being the subject of. The people who have said such things to me are well-meaning, but the underlying assumption is, of course, that I shouldn't be doing that well solely because I have a disability. So, getting back to the statement of findings, I suggest that you substitute the word "women" for the phrase "people with disabilities" and see how you would like it if the statement of findings read, "Most women have the ability to make decisions for themselves when they are provided the necessary information and support to do so." I think a lot of women and men would find the assumption insulting because it assumes that men have the ability to make decisions for themselves without the support of someone else, but most women could make those decisions with that additional support. Look at statement of findings, paragraph 3, quote, "Trusted friends, family members, and professionals can help people with disabilities understand the choices they have and how to live their lives." Again, the assumption underneath the statement is that first, trusted friends, family members, and professionals would not be people with disabilities. And second, that we who have disabilities need these people to help understand the choices we have and how to live our lives. Again, substitute for the term "people with disabilities" and see how you like this wording. Trusted friends, family members, and professionals can help women understand the choices they have and how to live their lives. That sounds pretty paternalistic. I also suggest in paragraph 4, if you were to substitute the word "woman" or "women" for the phrase "adults with disabilities," so that the sentence read, "Women have a range of strengths and experiences, and guardianship is unnecessarily restrictive in many of these circumstances." It kind of harkens back to perhaps a 19th century view of women as needing to be under the protection of men, but obviously they don't need to be. So I think that if you kind of simply substitute some language, I'd suggest that you might find other places in the proposed bill where the term "person with a disability" is not appropriately limited to the class of people that this legislation addresses, i.e. those who might be subject to a guardianship. In sum, the statement of findings that is proposed is overly broad and perhaps inadvertently perpetuates a negative view of all persons with disabilities, most of whom have never been nor will be the subject of a guardianship. So I have a suggestion. By amending the legislation to eliminate paragraphs 1 through 4 in the statement of findings, renumbering paragraphs 5 through 8 as 1 through 4, and adding in paragraphs 6 and 8 the words who might otherwise be subject to guardianship after the phrase person with a disability. You will eliminate this overbroad and inaccurate depiction of people with disabilities as a group and better serve the bill's purpose. So that concludes my written testimony. And I just wanted to say that with regard generally to supported decision making, I've been familiar with this for a while. I tell my clients that it's not here. It has not yet been passed in New Hampshire. I was asked by the Family Law section of the American Bar Association to contribute a piece to their journal a year or so ago about guardianship and its alternatives, and I mentioned that this is a hot topic because the ABA has adopted a provision supporting supported decision making as an alternative to guardianship. But you know, in my own practice and experience, I think the real issue is changing what guardianship is. So guardianship and the guardian sees him or herself as more of a mentor, because as Attorney Skibby stated, the reality with supported decision making, and I don't really take a position on this bill one way or the other, but my first reaction when I first learned of this concept a couple of years ago was well, that's what people are doing already. You know, if you've got a family member and you have a disability and you need certain assistance, such as my son, who is now in his 30s, we're doing that already. And he has powers of attorney, which is another alternative. So if I need to do something in consult with him as his agent, I can do that. He has not lost any rights of his own. In the educational context, I don't know if it was mentioned, but typically what schools will accept for a child who is 18, at which time in special education, the rights that the parent has automatically transfer to the child, is an educational power of attorney. And I draft these all the time for my clients, as I believe other attorneys may do as well. And basically what that is, it's your general power of attorney, which includes educational powers. So again, the child is able to make any decisions that he or she may want to make in terms of education. But it also gives the child the option of saying, well, you know, I don't want to go to that meeting. My parent can go, you know, and believe me, there's a lot of kids who don't want to go to their IEP meetings. There's a lot of parents who don't want to go to the IEP meetings either. And so again, you know, in thinking about alternatives to guardianship for people, perhaps this is not going to be the time for it. But I really think that the issue is more, you know, changing the nature of guardianship, making the guardian, if court appointed, someone who becomes more of a mentor and is understood that way, as opposed to somebody who basically can overrule the decision of the person who has the disability. Okay. I think that's all I have to say. I'm certainly happy if anyone has any questions about my perspective, or disagrees or agrees with my perspective, or has any questions generally about my own experience as a parent of an adult who has a disability, or the guardianship. I've represented many people, both as the proposed ward as well as the guardian and guardianship proceedings in New Hampshire over the last 30 years. And would be happy if there's anything that I can say that might help you make your decisions on this bill.
Okay,
thank you.
Thank you. Are there any questions? Representative, no? Okay. I see no questions. So thank you very much for your testimony today.
And I want to thank the committee and the chairman for giving me this time to speak.
Thank you. We have a Teresa Olson Martin who wishes to speak.
Good morning.
Good morning.
I wasn't sure it was going to work. This is my first experience doing this remote thing like this. My name is Teresa Olson Martin, and I live in Webster, New Hampshire. I want to be clear that I'm speaking as a private citizen, but I also work at a statewide organization that helps families who are trying to find the services and the supports that they need to raise their children and young adults with special healthcare needs and disabilities. I really appreciate the opportunity to talk to you about House Bill 540. I'm here to share information that I've learned both as a parent and as a person working with other families. My experience includes being the guardian of my 40-year-old son for the past 22 years and involvement in guardianship proceedings for my father. I also provided input to the writing of House Bill 540. Filing for guardianship was and is a difficult and emotional process. It's yet another time when I had to face the reality of what my son couldn't do. It's not something anyone looks forward to. Families who ask me about guardianship frequently ask if there are other options. They say things like, do I have to do this? He's working really hard to become more independent. He's still learning. I tell them that our current system allows for guardianship or things like power of attorney or healthcare proxy. That's what we currently have. Most people have some familiarity with those options, but they don't really feel like they meet their needs. Guardianship is unfortunately the choice most families make with a lot of reluctance. As parents, we don't want to stand up in court in front of our child, because it is expected that that young person be in the court, and talk about all their deficiencies and the labels that they've received over the years in order to gain guardianship so that we can continue to support them and help them. We want to be building up their self-esteem. We want to be telling others about all the great gains that we've seen and what we think can be accomplished with a little more time, how they're going to be able to do great things rather than doing the negative talk, especially when we continue to see them gaining skills and making progress. We're not being unrealistic. We're still being hopeful. However, we're also being told that we will have no input once the young person reaches 18 if we don't have guardianship. Schools are unaware of other options. Banks, lawyers, doctors have all been taught that as of 18, the individual makes all their own decisions unless you have guardianship. Families are seeking options that will help their young person to continue to gain the skills they need to take care of themselves without taking away their individual rights. Supported decision-making is a tool to assist the young person and the family. It allows the young person to maintain their ability to make their own decisions, and it gives the family knowledge that a plan is in place to support that family member. If families are provided information on options at schools and places where our kids are getting services, we can make informed decisions together about the option that is best suited for our family circumstances. I learned about supported decision-making about 4 years ago, and I've talked to families about it as an option. However, because it's not recognized by the New Hampshire legislation and the courts, they feel that it might not be acknowledged when they're working with others in their young person's life. And it's scary to do something that's different if you're not sure it's going to have validity to the professionals in their lives. How much pushback are you going to get? Are you going to have to constantly be explaining and trying to make your point? We're tired. It becomes one more thing to explain, and depending on your relationship with others, it can be difficult to have the acknowledgement that more than one person may need to be involved in this decision-making. Professionals who may have never heard of supported decision are the ones telling you that you have to file for guardianship. It's how you protect your loved one. We do want to protect our kids. We also want them to gain more and more independence. Families are conflicted, and I certainly understand those concerns. I ask that whatever you decide, that you remember it's a difficult process and families want to continue to be involved. Thank you, and I'm happy to take questions.
Thank you very much for your testimony today. Are there any questions? Seeing none, again, thank you for your testimony today. There are 3 other people who pre-registered to testify. None of them asked for more than 3 minutes, and we're getting to sort of the end of our time today. If they could present their, and they're all testifying in support of the legislation. So if they could provide their testimony. Representative Macbeth, did you have a question?
Thank you. When I signed up online, I couldn't check that I wanted to speak, but I'll speak at the end. I'm not asking to speak now, but I'll only take 3 minutes as well. Thank you.
Thank you. Okay. Is Jessica Goff available?
Yes, can you hear me?
We can.
Great. So honorable members of the House Judiciary Committee, thank you for allowing me the time to read my testimony. My name is Jessica Goff, and I'm a resident of Concord, New Hampshire. I'm a Master of Social Work student at UNH and a policy intern at the New Hampshire Council on Developmental Disabilities. I want to speak in strong support for HB 540. Members of the disability community and their families who live in our great state deserve a less restrictive alternative to guardianship. The practice of guardianship inherently removes the given rights of adults with disabilities to make decisions and engage equally in the world around us. Often, this legal transfer of choice-making power from what we call the ward to the guardian is done in totality and encompasses everything from control of money to making decisions around healthcare, education, housing, and even the ability to get married. For some, this means removing the right to vote and to testify in court. Given these severe limitations to an individual's autonomy, guardianship should be viewed as the last resort. But in order to reduce the rates of guardianship and allow for adults with disabilities to take a leading role in their lives, we need less restrictive legal options that assist individuals to make informed decisions with those who they trust. Supported decision-making has been hailed as a balanced alternative, as seen in the momentum throughout the advocacy and legislation across the country. As was talked about, a number of well-respected organizations have come out in support, including the National Guardianship Association. The stated purpose of appointing a guardian under current New Hampshire law is to, quote unquote, protect the well-being of incapacitated persons who are unable to provide for their own personal needs due to functional limitations. We need to recognize that well-being is a concept that should encompass more than just safety. We need to think about quality of life and access to the full rights of citizenship. In both the course of my graduate education and my previous work as a direct support professional with adults with disabilities, I've seen both the detrimental effects of forced control and the amazing benefits in the capabilities of individuals when they are given the opportunity to sit at the head of the table in making decisions that affect their lives. Right now, parents of youth who are transitioning into adulthood are given a seemingly impossible choice: to take their child's right to choose away, or to allow the young adult to preserve the legal rights, but eliminate their ability as parents to support their children in what they need to be successful. This bill would allow a comprehensive third option, which would enable adults with disabilities to keep their rights, but ensure that they have access to needed supports with the guidance and assistance of their supporters. I urge you to vote to pass on HB 540. Again, I believe that this is a really great bill. In the work that I've done, I've seen so many individuals who are very capable of making choices, who have a guardianship, often appointed by the state, who they may not even know. So they have individuals making choices for them without their input. Because guardianship is inherently taking someone's rights away, that is the purpose of guardianship. And so another option would really allow people to be able to get access to services and have that codified under law. So as Representative Gordon, you were talking about, as a doctor, under current law, an individual can have this decision informally, but if they bring it to you, you're not really sure who to listen to, who has the legal rights. But this would put it into law so that you're fully aware of exactly in what domains the supporters are able to get information, when they're able to be present in appointments to get that information, how HIPAA applies, and everybody is on the same page. So thank you for allowing me to provide my testimony.
Thank you. Representative Macbeth.
Thank you, Mr. Chair. So I apologize for being late this morning, but I actually was in the probate court.
Actually, Representative Macbeth, you said you wanted to go last.
No, I didn't have to. I just mean I don't want to jump, but I'll
Just hold on, and I'll get the other and let you have the last word. Okay. I thought you had I thought you were asking a question. Is Judith Jones available? Well, Ms. Jones, you need to unmute.
Well, the first law of speaking as an attorney is to unmute. Can you hear me now?
We can.
Thank you so much. So my name is Judith Jones. I've practiced law in New Hampshire since 1998. The focus of my practice has been on assisting older adults and individuals with disabilities. I'm pleased to have the opportunity to support House Bill 540. So you've already heard the testimony in favor of the House bill and focusing on that it's a model to support individuals with disabilities in communicating their own decisions in their lives. And it's really based on this. It's based on the premise that all individuals have the right to make decisions that impact their lives. As others have said, our current system is really based on substituted decision-making, another making a decision for me. What this does is really shift the framework of our legal framework from substituted decisions to supported decisions. And I thought most importantly today to use my time to give you examples of how this legislation could impact my practice. We've heard testimony from a parent, two parents, what seeking guardianship has done and the process, how difficult that was. I've had the opportunity to represent a number of parents in guardianships and also represent proposed wards. And the common issue we see among parents facing an individual child turning age 18 is really anguish about the guardianship process, guardianship about the court, the difficulty with the court process and having to go through a litany of a child's deficits. I think of two cases I have where there is a guardianship in place, but with the passage of this bill, I think there's a potential to revisit the need for a continued guardianship. One of these individuals is involved in a life skill training course, and she's been very, very successful. Another individual shows the ability to, on her own initiative, reach out to other professionals to get information to make decisions. An example that really goes to what Representative Gordon raised is one where my colleague had a case where we had a very, very intelligent client with cerebral palsy who had difficulty communicating his needs, and a parent who was very skilled in understanding what her child wanted and understanding his medical history. And this is a case where the parent was a natural fit for the supporter. Like Attorney Skibby, I acted as a caretaker for my own mother, and I look at how this legislation could have impacted that relationship. And though I had the ability to act as her supporter and did so, what I found was mostly often in a busy medical practice, what happened to me as the person acting as the helper, everyone naturally looked to me to make the decisions, and the focus was not on my mother. What this legislation would do is make clear, I'm the supporter and this is the decision maker. And while I was able to redirect the providers, I think that this kind of contract and this statute would enable and support a further shift in our legal system from substituted decision-making to supported decision-making. Finally, what I thought about with this testimony today is just so pleased to be able to practice law in New Hampshire. And I thought about other states have adopted this legislation, but you look at our state with this proud and long tradition of respecting rights of individuals and promoting self-determination. And I believe that House Bill 540 really is the next step in the evolution of our law to actively promote and honor the ability of all persons. And what better state than the live free or die state? Thank you.
Thank you very much. Are there any questions for Ms. Jones? Seeing none, thank you for your testimony today. And the last person who pre-registered to testify is Lisa Bowden.
Good morning or good afternoon at this point. Thank you. It's been an exciting opportunity for Able New Hampshire to work with all the stakeholders who brought forward this, and we appreciate that Representative Chase is sponsoring this bill and all the work that Mike Skibby and the other folks who worked to get this legislation moved forward. My name is Lisa Bodwin. I'm the Executive Director of ABLE New Hampshire, and I appreciate your time and attention on House Bill 540, a bill to create and establish the supported decision-making model here in New Hampshire. On behalf of ABLE, its board, and members across the beautiful Granite State, I'm asking you to support HB 540. As you know, RSA 171A established New Hampshire's community-based system of supports and services for people with developmental disabilities. A key element of having a community-based life is the ability to be self-determining. Supported decision-making is an important, viable alternative to guardianship, which advances the development of skills for self-determination. It was nice to hear Attorney Jones just now reference how New Hampshire has been at the forefront of asserting rights for people with disabilities. You all know that New Hampshire closed its state institution 30 years ago in the effort to advance human rights for people with disabilities, essentially to make real the opportunity for these citizens to access the American dream too. Supported decision-making is yet another tool in the quest to fully include people with disabilities, these Americans, in the dream. Supported decision-making is a process that facilitates people to become and remain more integrated in the community. More importantly, research shows that this model increases protection against abuse and exploitation. Just a couple of more points on why supported decision-making is important. It's a means to empower people with disabilities and the aging to remain at the center of decision-making processes in their lives. Research also shows that maximizing choice and control in a person's life increases positive health outcomes, happiness, and safety through stronger relationships and better ability to recognize and resist abuse. And one of the reasons why supported decision-making appeals to me personally as a parent and not just as a professional is the idea that supported decision-making is normal. Most people use informal supports in making personal decisions. Just like you and I, we seek the advice of trusted friends and or family on medical, financial, personal, professional, and other issues. Let's create a structure for people with disabilities to have what's typical. Please support HB 540. Supported decision-making will enhance dignity for people with disabilities.
Well,
Thank you. Did you? Thank you. Thank you.
okay, any questions for Ms. Bowden? Seeing none, thank you for your testimony today. And that concludes the people who pre-registered. Is there anyone else, any attendee who wishes to testify? There are a couple of hands. There's a Cheryl Steinberg. We're over on our time, so if you could keep your testimony succinct, it would be very appreciated.
Yes, can you hear me?
We can.
Okay, yeah, I'll be very brief. I appreciate it. My name is Cheryl Steinberg. I am the director of the Senior Law Project at New Hampshire Legal Assistance, and I'm here today to testify in support of House Bill 540. You've already heard all the reasons why it should be a good thing, and I support all those reasons that have already been mentioned. And I was on the work group that helped draft the bill. I think it was very well thought out and well reasoned. And I would just say in my experience, of over 20 years working with older adults, I can absolutely see the need for this and the value. I've talked to many people who are kind of in this in between, you know, able to make some decisions and not others, and they're under a guardianship. And I can tell you how distressing it is for them. I mean, if you can just even imagine the distress when you might have to tell a parent, you can't drive anymore, we're taking the car keys away. I mean, how devastating that one act is, and just to have a guardianship where you can't even make any decisions for yourself, how distressing that could be. So any kind of tool that we can have at our disposal when appropriate to allow people to maintain their decision-making ability, I think is a good thing. And I'll just end there. I just would urge you to vote to pass on the bill.
Thank you for your succinct testimonies. Appreciated. And are there any questions for Ms. Steinberg? Seeing none, thank you. And Diane Bessie?
Can you hear me now?
We can.
Great, thank you so much. Thank you, Chairman Gordon and the entire Judiciary Committee for allowing me to speak today. As the Executive Director of the Monarch School of New England, an approved private special education school for children with disabilities located in Rochester, I am pleased to support HB 540 and the concept of supported decision-making as an alternative to guardianship. Over the past 23 years, I have had the pleasure of working with many parents and students preparing for the transition to adulthood. It is a stressful and busy time for all parents and students that face many decisions ahead. Since we work with students and their families for a number of years, we develop trusting relationships over time. As a school, we work hard to instill independence at every level of function, teaching our students to self-advocate whenever possible. We presume competence and concentrate on what a student can do on their abilities rather than their disabilities. It is simply joyous to facilitate a student's development from complete dependence to self-confidence. When students learn to communicate their thoughts and feelings and understanding, the possibilities are endless. While guardianship is appropriate for some students, for others who are able to self-determine their path ahead, with or without the guidance of a trusted individual, supported decision-making allows them the freedom and independence they should have in making choices in how to live their lives. Because we want families to be fully informed as students reach the age of majority, the Monarch School of New England looks forward to sharing materials developed by the New Hampshire Department of Education that will clearly outline all options along the continuum, including power of attorney, conservatorship, guardianship, and SDM. While it is true that IEP teams have the most contact with students with disabilities and their parents, making the IEP team appear to be the ideal entity to share these options, in our experience, sometimes parents select to work outside of the IEP team with area agencies or caregivers from a community mental health center to carry out this critical step. Whilst these entities will follow students until the age of 21, while school districts will not. Would it not make sense to hold other entities responsible as well for presenting and discussing the options available? I do not want to see any individual with a disability fall through the cracks. Yet, as an administrator, I fear any consequences should a school inadvertently fail to inform the family of the choices other than guardianship because so much is going on at this busy juncture in a student's life. Thank you for the opportunity to testify in support of HB 540. I look forward to watching HB 540 continue to develop, bringing greater opportunity to students with disabilities, and greater control over their own lives. And I'm happy to answer any questions that you may have.
Are there any questions for Ms. Bessie? Seeing none, thank you for your testimony today. And I see no other hands up among our attendees, and I will declare the hearing closed on House Bill 540. Oh, I'm sorry, I forgot my promise to let you testify, Representative Macbeth. Sorry, go ahead.
I'm a little bit intimidated because I think all the people that presented testimony before, the practitioners have more experience, years of experience than I do in this area, and the people with personal experiences certainly had a lot of impact. I just said I do practice in this area. I just had a wonderful hearing this morning on a petition for guardianship in the Brentwood probate court. I want to let you know that for those of you that don't, and Wendy, would you hold your hand up at 3 minutes so I know when I'm done? But I do see this. I'm speaking in favor of this idea. I don't see it as a replacement for guardianship. I definitely see it as a good alternative. I want to assure everyone that New Hampshire 20 years ago was on the cutting edge of our guardianship law. We make it so that every guardianship is tailored, and I can use a prop. This is a page, just one of the 4 pages on a petition for guardianship. And there are specific, every right, civil right that's removed from somebody, and it is removing a civil right and transferred to the guardian, has to be written in the petition, and an attorney like me, by statute, is appointed to discuss it with that proposed ward. And even this morning, after the petition was granted, on the limited issues that were either contested or not contested, the judge did say, reads from and explains to the guardian that they are under fiduciary responsibility to safeguard to the greatest extent possible, even in the rights they've been given, transferred, that they must safeguard the ward's rights. So I just want to say that. But I want to tell you, this is the top of the petition, and it is very difficult for me to go and talk to somebody and tell them that a petition for guardianship, declaiming them as an incapacitated person, is not always appropriate. And what also is not always appropriate, what we've had testimony, is this removal of all self-determination from that person, even if people that need help. It is an adversarial proceeding, and the person that is under a guardianship is known from there on out on every form as the ward, which can be really, really inappropriate. And 2 instances of this are, a 42-year-old that I worked with years ago that had a motorcycle accident, paralyzed from the neck down. He's not an incapacitated person. He's a person that needs supported decision-making. But anyway, he was, those were our options. You also are talking about people that even if they might be able to be trained in technology, these are people that don't have the resources for that. And in New Hampshire, we don't provide those resources. Another guardianship, a 60-year-old woman who had cerebral palsy when she was younger, at birth, and had never had a guardian, 60 years old, but because of her, I think really her presence, the way she presented herself, and her inability to communicate clearly to people, a guardianship was really the only option she had, because a lot of the communication is by phone. She wasn't able to travel places because of lack of transportation. So again, I am really supporting this as an option. I'm very interested by Attorney Zachary's comments about removing the disability, because when I think of my mom and how much I'd like to help her and be a supported decision-making, she's 85, she's not under a disability, any disability except maybe insecurity, because she lives in a youth-centered culture, and also because she has anxiety around some technology. So I see this as the reason why a guardianship is so powerful. And why I think this would be, and it goes back to Chair Gordon's comment, this really authorizes people, the professionals, it makes it okay for agencies and entities to share information with another person. And that's one of the reasons, particularly in the 60-year-old woman that I was talking about, she was getting run over by agencies and people, and she needed an advocate that had a paper that said, you have to listen to me. So anyway, I'm so grateful that we're talking about this. I think it's so important, and I think there's some things that might need to be worked on, but I'm thrilled to have it in a toolkit for the citizens of New Hampshire. So thank you. And I know I spoke more than 3 minutes. I apologize. Bye-bye.
Well, thank you for your enthusiasm. So, and are there any questions for Representative Macbeth? And seeing none, we'll close the hearing on House Bill 540. We will recess and reconvene at 1 o'clock. Thank you, everybody.
Thank you, Mr. Chair.
Very good. Yeah, we just got done the last thing for the morning. Very good chance of doing that. Yep. So back. Well, so Matt's on the job, we're supposed to have 10 minutes. Your side. No, anymore. Well, it's more or less agreed. Just go 3 minutes. And I told people I would keep mine, whatever he did, I would keep mine. Put on for 10 minutes. Yeah, I guess some a lot of people told me this. A lot of people told me they saw me on TV. And I don't think it was said or not. They would see me. I just can't answer that. Really? Oh. Well, Well, they walked out about that. They walked out of the corner. Well, and the worst part of it, it didn't even have a beep. Okay, so what happened was, we had a time that, well, we were near the end of the day. We were told partnerships. We completed what we had to do. It was what we were to. So since we hit the goal, our leadership decided we should move that go forward from that. That's a strict power. With some absolutely according to the rules. Maybe it's because they lost the previous one. No, mine's zero. Besides, you get to rearrange your horses. In 1 second. It's my son, I have to answer. I'll call you back soon.
Mr. Welper,
Yes.
this is Mark Page. I just want to let you know you're not muted on the judiciary.
I didn't even think of, can you hear me now?
I can hear you. Yes. I just want to let you know. I didn't know if that was, I just want to let you know.
Sorry.
Good afternoon, everyone. We'll call this meeting of the House Judiciary Committee back to order. And our work for this afternoon is a hearing on House Bill 440 relative to the protection of religious liberty. The primary sponsor of that bill is Representative Jim Kofalt. And Representative Kofalt, would you like to introduce your bill? And I need to be made a host, I think, in order to allow Representative Kofalt. There we go. Representative Kofalt, I
Thank you.
think you're on.
Thank you. Thank you, Mr. Chairman. Can you hear me?
We can.
Thank you. So HB 440 is a bill to protect religious liberty in New Hampshire. And I also want to direct your attention to the fact that I have been discussing a proposed amendment with Representative Sylvia, which I believe he has shared with the rest of you. So I will speak to the original bill and the proposed amendment as well here, if I may.
You may.
James Madison, the architect of our federal free exercise clause, wrote that the right to free exercise of religion is held by the same tenure with all of our other rights. The intention of this bill is to ensure that that intent is honored in the state of New Hampshire. In effect, it directs judges to treat Part 1, Article 5 of our state constitution as an enforceable legal right. One may ask why that's necessary. And essentially, it comes down to the fact that in some judges' chambers around the country, there has been a school of thought that holds that constitutional protections for religion should be viewed as a matter of preference, not necessarily a strictly enforceable right. And so the intention of this bill has been to underscore legislative intent to treat religious liberty as a strictly interpreted constitutional right. Fortunately, our state Supreme Court has not taken that view that I mentioned earlier. They have come down firmly on the side of religious liberty. On December 22nd, after this bill was filed, the Supreme Court decided the case of New Hampshire versus Mack. And in that decision, they asserted the right to free exercise of religion, stating that Part 1, Article 5 must be applied by New Hampshire judges. And so in essence, what that ruling does is it provides the protection that this bill was intended to guarantee. So we could potentially proceed with this bill as a sort of a statutory fallback to the court's decision. That wouldn't necessarily be a bad thing. However, there's another concern that has come up that I think really is required in order for us to underscore this protection of religious liberty, and frankly, for that matter, all other civil liberties guaranteed under the U.S. and New Hampshire constitutions. The proposed amendment addresses the question of whether constitutional rights may be suspended during a time of crisis. And although that may sound like an unlikely scenario, it is actually the current state of the law right now in New Hampshire. In 2020, the New Hampshire Superior Court issued a ruling in which they stated, and I quote, "The governor may suspend or limit constitutional rights during a state of emergency." So looking around New Hampshire, you might not guess that we're living in a world where constitutional rights can be suspended. Churches are not closed, guns have not been confiscated, and citizens are not being pulled off the street and held without due process. However, we are, somewhat interestingly, living in a situation right now in which the state of New Hampshire takes the position that we do not have enforceable legal rights under the U.S. and state constitutions. When a governor issues emergency orders, he acts under the emergency powers delegated to him under RSA 445 and 47. The proposed amendment simply adds a clarification. And I would direct you to Section 6 of the proposed amendment, which really contains the relevant language here. It's 2 short paragraphs, and they are almost a repeat of each other. The proposed amendment simply adds the clarification that, quote, civil liberties shall on no account be suspended, nor shall the United States Constitution or the New Hampshire Bill of Rights be suspended, set aside, or infringed. So that is a very narrowly defined clarification, very limited in scope, clarifying the legislature's intent concerning the governor's emergency powers. That would bring us into the company of multiple other jurisdictions around the country, including Maine. The governor currently has enumerated powers, actually very flexible enumerated powers to deal with an emergency, and this would not change that. It would simply ensure that in challenges to any of the governor's actions or any future governor's actions, the courts would need to conduct an ordinary constitutional analysis rather than simply declaring that civil liberties are suspended. And with that, I will take any questions.
Yes, Representative Horgan. Need to unmute.
Now I'm unmuted. Oh, thank you very much, Mr. Chair, and thank you, Representative Colfall, for taking my question. You had a quote from James Madison, which I guess is something you're planning to. It's a quote from something called the Memorial and Remonstrance Against Religious Assessments. So what's, which is actually, it's not in the amendment, but what's the, what was that in the, what was the larger context for that? Like, what was that? What was the large, what was, of course, in a religious assessment sounds like, I know in New Hampshire and most other states, like the state used to support at least certain religions, which they don't directly do anymore, although we do get property tax exemptions and other benefits. So what was the context for that quote that you started out with?
To be honest, I don't. I put together my notes some time ago, and I don't recall the exact context of that.
Okay, fair enough. A follow-up. And so what definition? I mean, like I see stuff with religious organizations and religion. So what's to stop just somebody from just creating just any type of organization and calling it a religious organization, and then thus exempting themselves from at least some laws? So like, where's the protection? So what sort of protection?
That's a great question. There have, and so as I was researching some of the case law surrounding religious liberty, that is one concern or objection that comes up fairly frequently. In actual case law, however, we have not seen that happen. In other words, the courts have done a fairly good job of distinguishing between, or quite a good job, I would say, of distinguishing between bona fide religious liberty cases and and cases in which someone comes up with sort of using religious liberty as kind of a shield for activity that would otherwise be prohibited.
Okay, thank you very much. Thanks.
Representative Kelly.
Thank you, Mr. Chair, and thank you for taking my question, Representative Kofal. Could you give a specific example of the kind of future case you're worried might happen if civil liberties can be suspended?
Well, I can tell you that, in the case of religious liberty, generally speaking, the Mack case actually is which I mentioned in my testimony, is actually an interesting example, because that was an example pertaining to the religious use of psilocybin mushrooms, which are psychedelic. And in this case, the defendant was part of a legitimate bona fide religious organization that used those in, as part of their religious rituals and ceremonies. And so, this was where, the distinction really is that the state must make a compelling case. If an activity is otherwise prohibited, such as the use of psilocybin mushrooms, if a case is otherwise prohibited, or generally prohibited, I should say, the Supreme Court rulings throughout most of history have taken the position that religious liberty would prevail unless the state can demonstrate a compelling interest in the prohibition. In that case, there was not a compelling interest in the prohibition. I think there have been some concerns about prohibitions on religious gatherings during emergencies. The bill actually would not. The bill was not intended, as originally written, was not ever intended to stand in the way of those. But there have been other there's been other case law. One, and I'm trying to remember the citation, but there was a Supreme Court case involving the collection of sales taxes in Utah when someone was selling religious pamphlets and tracts, and they claimed exemption from sales tax because it was a religious activity. It went to the U.S. Supreme Court, and the Supreme Court ruled that there was ultimately a compelling there was not ultimately a compelling state interest, and that it was protected religious activity, protected from sales tax. There was a similar case involving a plaintiff who sued a state that had denied her unemployment claims because she was a Seventh-day Adventist. She refused to work on Sunday. She was fired from her job, went to collect unemployment, and was told that you don't really get unemployment, and because you refuse to work on Sunday. And so again, the state was unable to demonstrate a compelling state interest in the position of not paying unemployment in that case. So these are some of the kind of borderline cases. Again, the MAC decision effectively establishes a clear line for how those should be decided, which is that they should come down on the side of religious liberty. The concern is that we are living in a situation right now under the Superior Court decision from last year that effectively says, quote, civil liberty, the governor may, let me find the quote, the governor may suspend or limit constitutional rights during a state of emergency. That calls into question all of our constitutional rights. And, in that respect, this really is, it remains a protection of religious liberty, but in many respects, it is a protection of all civil liberties by clarifying the legislature's intent that emergency powers are not intended to allow the governor to override, suspend, or limit constitutional rights.
I have just one more quick question, if I may. Is there a possibility that even if this bill passes with the amendment, a governor could still suspend civil liberties under a theory of inherent powers?
I don't know. I know that there is someone who I think was trying to sign up to testify. I believe he was not. He called me shortly before this hearing and told me that he was unable to uncheck the box, indicating that he wants to testify. Ian Hewitt should be on the line and probably raising his hand, but he would be the better person to ask that question, I think.
Very good, thank you.
Representative Birch.
Thank you, Mr. Chair, and thank you, Representative, for taking my question. My question is a follow-up a bit to Representative Horgan's question, and also your most recent responses. I read the MAC case a little differently than you do, but isn't it true that the New Hampshire Supreme Court basically said that anyone can entertain what religious thoughts they wish and make a religion out of them, and that the courts can't step in and decide what's theologically correct and what's theologically nonsense?
Again, I would perhaps defer to Attorney Hewitt on a more detailed analysis of that. My understanding of the court's position is that it is not their place to determine the theological correctness, but it is their position that they may determine what is a legitimate bona fide religious activity versus what is not. But I would ultimately defer to Ian Hewitt on that one.
If I could follow up. Actually, I think in the Mac case, it was stipulated that this was a bona fide religious practice, the psilocybin stuff. My question to you further is, you talked about the tax, people in Utah not wanting to pay the sales tax or whatever kind of tax you referred to. Would your bill affect a situation that has arisen in my neck of the woods in New Hampshire, where I say this without any negative connotation, the Free Staters in our area decided in order to not pay property taxes to incorporate themselves as a church, and did so and gave themselves religious titles, and then litigated with the town of Keene or city of Keene whether they would have to pay taxes or not. Are you suggesting that this legislation of yours would bless that, to use that term, would bless that effort, and that perhaps we could all turn our homes into churches and avoid paying property taxes?
This legislation as amended would actually not do any such thing. It would be quite narrow in focus. As I said, it would establish that the governor may under no circumstances limit or suspend constitutional rights under the emergency powers in RSA 445 and 47. So it really pertains as it is written right now, or written in the amendment. It would pertain specifically to the question of whether the emergency powers may be suspended, or whether constitutional rights may be suspended or limited under the emergency power statute.
Thank you.
Are there any other questions for Representative Kofal? Seeing none, thank you for your testimony today.
Thank you.
And I think since we're talking about a potential amendment, I'm going to call upon Representative Sylvia next, and he can address the amendment, I think.
Sorry. Thank you, Mr. Chairman. Representative Kofalt brought this idea to me, and I certainly am very much supportive of this. Where he initially started out in Part First, Article 5, I think we can now look to Part First, Article 10, where we affirm the rights of all people in the state without regard to any special classes of men or people or even religions. So I fully support this amendment, and I think it's a great tool, particularly in the case of these emergency powers, that we need to be able to challenge any unconstitutional orders produced by the executive.
Any questions for Representative Sylvia? Representative Sylvia, if I just, the amendment, and I'm sorry I don't have it in front of me, and I'm afraid to go out of the Zoom and do that because I'm afraid I'll screw up my Zoom connection. But so I'm just asking, does the amendment, I thought I heard them say at the beginning that the amendment would replace bill as it's currently written.
Correct.
And I also think I heard it said that the amendment was just 2 paragraphs. Is that accurate?
So there is a lot of preamble to it. The first 5 sections And then section 6 and 7 get down to the actual statutory language. So there's just a couple of sections that revolve around the Emergency Powers Acts.
Okay, thank you. Representative Horgan?
Thank you very much, Mr. Chair. Thank you, Ms. Sylvia. Do you feel like expounding on which of the emergency powers were unconstitutional and which aren't? So like what exactly was it based on our experience over the last year that you're trying to prevent from happening in the future should we have another pandemic or other catastrophe that kills 500,000 Americans, including 1,200 here in the US. So which ones, any that you're particularly concerned about in particular? Thank you.
Thank you for the question, Representative Horgan. I think that there is a fairly serious question about the ability of the legislature to delegate powers to make law, and that question is part of one of the remonstrances, and frankly, we should take it up and we should make clear whether or not the delegation of that authority is actually within the Constitution. And perhaps Attorney Hewitt, when he comes up, will maybe address that a little bit.
Okay, I get it. I mean, this is, I don't want to get in territory that we would want to waive the executive session, but I guess isn't it true the legislator did eventually find a way to come back within 3 months of when the pandemic was, and they probably were trying to do it earlier? Or so do you agree? So how do you feel? So do you have any comment on that aspect of it? The fact that at least and there are like some legislative, like there's, for example, the Joint Fiscal Committee attempted to continue meeting, but then the governor never referred any of the emergency expenditures to it. That's a little bit off the topic of religious liberty, but.
Right. Well, as the bill is amended, when the legislature comes back, a lot of these emergency orders could be done legislatively, and obviously it's a much slower process. So the ability for the governor to act. I mean, we went a couple hundred years without this statute, RSA 445 and 446, 447. I'll be speaking to 446 next Friday, I believe. And we managed to get by. We managed to get through the Civil War. We got through the Spanish flu. We got through World War I, World War II. We managed to keep the state from falling apart. And I think that a lot of this is unnecessary and superfluous.
If I could just jump in with a question, Representative Sylvia. If and that is, I can agree with you that there needs to be changes in emergency powers. And my understanding is the only reason the governor has emergency powers is because we've statutorily given him those emergency powers. So why, and I guess the question ultimately comes down to this: why not address the concerns that have been expressed in terms of changing the governor's emergency powers or limiting them, as opposed to this approach, which seems more heavy-handed?
Thank you for the question, Mr. Chairman. I think we've been wrestling for quite some time about how to get this whole system to work where everybody is in agreement, and I think we're a long way away from that. I don't know, this is our, I guess, best attempt at coming up with something that will be workable.
Representative Birch?
Thank you, Mr. Chair. Thank you, Representative, for taking my question. I was looking at the language in Section 7 saying that provided that civil liberties shall not otherwise be infringed in the time of emergency. So let's say there's a mammoth flood in Concord and it's just a tremendous human disaster and an emergency is going on and the governor wishes to say no large groups of people shall gather in the center part of Concord because it's a disaster area. Are you suggesting by this bill that the governor should not be allowed that power?
Actually, I would say yes. I mean, let's look at, if we use your example, we can look at Katrina and the flood there. There was those folks that came out with their boats to come to the rescue, and they were stopped from assisting. So we might have a large group of people coming together to help, and the governor, perhaps one person making that decision is not necessarily the smartest person, sorry to say, not speaking to anyone in particular. So these things with top-down central control, I'm not sure that we really want that.
I've got no further questions.
Okay. Any other questions for Representative Sylvia? Yes, Representative Chase.
So are you're saying that in a disaster or where other people's health can be affected, that you feel it's the right to still be able to congregate together? Basically, is what I'm asking you, because I could go on and on, but you understand what I'm saying? You just override?
I do, and actually the Constitution does speak in one section about health emergencies. And there is a time and a place for quarantines. So that is a power that's in the Constitution that the governor has, but it's limited. And I think the current situation, in my opinion, does not reach the level of an emergency.
Okay, thank you.
Thank you for the question.
Okay, any other questions for Representative Sylvia? Seeing none, thank you for your testimony.
Thank you.
We have several people who have we have a couple of people who have pre-registered to testify today. One being Susan Price. Hello, Ms. Price.
I think I'm unmuted.
You are.
Oh, thank you, Mr. Chairman and committee members. My name is Susan Price. I live in Moulton Borough. I do support this bill. I have not seen the amendment, so I'll only be speaking to the primary bill. My focus is on essential services. Those who do not belong to a church or actively involved in a church may not understand that churches provide services beyond direct ministry in the religious sense. So my focus and the reason I support this bill is because churches need to, in times of crisis, provide many essential services. The New Hampshire Food Bank is operated by Catholic Charities. Imagine if Catholic Charities had not been able to operate that essential service. I think the New Hampshire Food Bank is an essential service. The same with the Salvation Army. They have a very large facility in Laconia. So there seems to be a misunderstanding in the secular population that churches do not provide essential services. There seems to be this focus that going to church on Sunday and going through whatever denomination you are, or your synagogue or your mosque, that those entities only provide direct religious services, when that could be the furthest from reality. Unfortunately, due to the governor's order, many smaller churches, including the one that we attend in Moldenboro, the United Methodist Church, we were forced to close our doors. And we could not provide essential community services, many of which that are provided to non-members. So that's the reason I'm supporting the bill. I seriously, in all practicality, I don't think it's going to make it past the governor, but I do think it warrants a discussion and more like a teaching lesson for people who do not really understand how churches essentially serve their communities beyond showing up on Sunday morning at 10 a.m. So thank you for your time, and I hope you'll consider my comments.
Thank you, Ms. Price. Are there any questions for Ms. Price? Seeing none, thank you again for your testimony today.
Thank you.
The only other person who pre-registered to testify is Nathaniel Diaz Rua. And I'm looking, but I don't see his name on the list of attendees. So I will call on other people. There are some other attendees who do wish to speak. One of whom has already been mentioned. That's Ian Hewitt.
Good afternoon, Mr. Chairman. Can you hear me?
We can.
Fantastic. Well, I hope I can help provide some clarity here. There's been a lot of discussion of religious liberty and of the MAC decision. And I do believe that the MAC decision provides the protections that are in the bill as amended. And so for that reason, I think that discussing, not the bill as amended, but the bill as originally written. And so for that reason, I think probably discussing the bill as originally written might not be the best overall use of our time. I certainly am passionate about and focus on religious liberty. And so if there are questions about whether religious liberty is a workable right, I'm happy to discuss those. But the MAC decision does already provide those exact protections for religious liberty. So if there are questions about the bill as introduced, then those same questions would apply to the MAC decision itself. The amendment, as I understand it, would wholesale replace the text of the original bill. And I think if any representative ever has a good excuse and reason to do that, Representative Kofalt does, as the court, after he had introduced the bill, issued a decision providing the protections that were in the bill as introduced. So I think he has a good reason to use this bill to address a related but larger problem. The problem that's addressed by this amendment is not religious liberty or gatherings or another partisan issue. The problem is that our Superior Court cases are pretty clear in saying that during a state of emergency, if someone brings any kind of constitutional challenge, and that may not be religious liberty, that may not be about gatherings, it could be about speech, the courts will simply not do a constitutional analysis. I think if members of this committee read through some of the reasoning in the Superior Court's Binford decision, I think some members on both sides will be quite alarmed. The court there was quite explicit in saying that under our current emergency powers, constitutional analysis simply doesn't apply under any constitutional challenge to an emergency order. The court will simply ask whether there's some factual basis connecting the order to the state of emergency, and if it was in good faith. That allows virtually any right to be infringed, and the court was very explicit about this. Now, I disagree in part with something Representative Sylvia said. I don't agree that if we change our emergency powers law so that constitutional rights can't be suspended, that will mean the governor can never prohibit gatherings. New Hampshire is in the minority in that our courts have said constitutional rights can be suspended. What many other courts are doing in Maine, for example, is saying constitutional rights can't be suspended in a time of emergency, but these emergency orders pass constitutional muster, emergency orders limiting gatherings and things. So we would not have chaos in our state if we effected this change. We would be in the same position as Maine, which has a somewhat lower case count than us, by the way. And if I could, I'll just walk through a specific hypothetical of how what I would characterize as an abusive case could easily play out under our current law. So suppose 5 or 10 years from now, there were a legitimate emergency in New Hampshire. And let's say that the governor decided on the basis of a good faith belief that media coverage of that emergency was causing alarm in the state. So the governor issued an order under his emergency powers saying that media in New Hampshire simply may not cover or report on the emergency. And let's say the union leader or someone sought an injunction under the First Amendment challenge. The analysis that our superior courts have used, in, for example, the Binford case, is just twofold. Is there a factual basis connecting the order to the state of emergency, and was it in good faith? So in my hypothetical, where if the union leader seeks that injunction, there is a factual basis, no doubt about that. It's connected to the state of emergency. And we've stipulated the governor in good faith believes media coverage is causing harm and panic. So the court would simply, as a matter of course, then dismiss that suit. It would apply no First Amendment analysis. Now, under ordinary constitutional analysis, what the court would do there is it would say this is a content discriminatory order, so we're going to apply strict scrutiny. But under the suspension of civil liberties theory that's current in our superior courts, that analysis simply wouldn't happen. So the governor can do these other things. The governor can try to limit gatherings. The governor could do everything the governor in Maine is doing right now. But the concern is potential future situations where the governor would have effectively unlimited power. I recognize some of these specific issues, religious liberties, gatherings, maybe Second Amendment issues are more partisan. But I think if there is one civil liberties issue where there could be some bipartisan support, it should be on this question of whether civil liberties in their entirety may simply be declared suspended, and whether courts can say we simply aren't going to do an analysis of these liberties in a state of emergency. And the last thing I'll say, and I'll take any questions, is in response to something Chairman Gordon said, just putting aside the original language, what this bill as amended would do is precisely amend our emergency power statutes. I agree with you, Chairman Gordon. The superior courts have said that they are reaching these conclusions under the current emergency powers statutes. So we could amend 4:45 and 4:47 to say the governor has these very flexible enumerated powers in a state of emergency, provided that civil liberties may not be suspended. And what that means is not that the governor can't limit gatherings, can't do all kinds of things that most governors in other states are doing. It simply means that when specific orders are challenged, the courts will do the normal constitutional analysis under those challenges, instead of just saying, you don't have these rights right now. So that's the goal of this bill as amended. I hope it's possible to have at least some bipartisan support. And I'll say lastly, if there is any member of this committee who suspects that the amendment really is a backdoor for some more partisan issue, I hope you'll question me about that. We can start that discussion, and that you'll give me a chance to explain why that's not the case. And I'm happy to take any questions.
Thank you, Representative Horgan.
Oh, thank you very much, Mr. Chair. Thank you much, Attorney Hewitt. Guess I'll do link together a couple of non-hypothetical cases that happened up here in northern New England. The first part of it was there was a religious gathering in central Maine. I guess it was a wedding ceremony, I believe, which I guess is not necessarily a religious gathering, but this one was, and a large number of people attended, apparently without observing the various precautions that are taken more for granted now than they were this summer, and which aren't. And so that those people who attended, it caused it caused hundreds of other COVID cases, including a number of deaths, quite far afield from the gathering, probably some even in New Hampshire. I know, for example, it caused an outbreak at, I think, the York County Prison, which is a county that adjoins my county. And then subsequently, so the second non-hypothetical case, which is the same issue, was we had a representative from New Ipswich had a basically a tent revival on his property and sent, and then they sent people out to, and then they sent attendees at the tent gathering, went out to other homes in New Hampshire, Massachusetts, to proselytize, and there was a controversy over how to address that. So, so do you feel that religious organizations should be held to a lower standard for those type of precautions than non-religious organizations would be, who also are peacefully assembling for whatever purpose they're assembling for?
Well, there is a distinct right for religious gatherings. There are rights, general rights to assembly in our Constitution, but there are specific rights for the free exercise of religion, whereas there's not specifically enumerated rights for like a labor organization. So there is a special right that can be applied in those sorts of cases. That you could bring a state free exercise challenge under now the MAC decision. So that's already in place. Now, I think the question at issue here is if, let's say, I were to represent one of those religious groups and sue for an injunction under the free exercise clause, would the courts apply the ordinary free exercise analysis under the MAC decision? And if they did, that doesn't automatically mean they would allow the gatherings. The court would just ask, is this narrowly tailored to achieve a compelling government purpose? Just the ordinary constitutional analysis. But under a suspension theory in a state of emergency, the court would apply no constitutional analysis. It would say, this is an emergency, this is a good faith action, this is connected to the state of emergency, and I'm going to throw this case out. Now, I will tell you, setting aside what I think should happen, I think it just is correct that if our courts were instructed under this amendment to do regular constitutional analysis, I do think that in the situation you're describing, our superior courts would find that the orders were constitutional. I happen to think that the orders that were challenged in Binford itself actually were constitutional. And I think if the court had just done an ordinary constitutional analysis, it would have upheld those orders. What's troubling is the precedent these courts have set by saying constitutional rights flat out don't apply, and we just won't do analysis. And that applies not just to cases, Representative Horrigan, where you and I might disagree, like religious gatherings, but all other kinds of civil liberties cases. For Fourth Amendment cases, in Binford, the court mentioned, it quoted an 11th Circuit case, AVO, I believe. And in that case, and in the quotation from that case, the court was quite explicit that the First Amendment is among the rights that can be suspended, including just, ordinary speech rights. So the idea that civil liberties can be suspended in an emergency undermines all of our enumerated civil liberties rights, including some where I expect we would agree, and not just these religious gatherings type of situations.
Horgan, are you okay?
Oh, well, I'm fine, but I've got a follow up.
Please.
First, this is also a political rather than constitutional question, and I probably a little bit outside this bill, but do you think we need to recalibrate sort of the relationship between church and state? Like James Madison's name came up at the beginning, and controversy in that case was, churches were directly subsidized by the state. In fact, they were part of the state, and they relied on for a lot more range of services than they are now. And then Susan Price, who came by way as a former state rep from Barrington, who since moved to Bolton Borough, but she pointed out that her church in Bolton Borough, provides a lot of services, and then gets, for example, and then she didn't mention it, but gets property tax exemption and a variety of other subsidies from the state. So you think perhaps would it be a good idea moving forward to deal with perhaps to reduce the subsidies and perhaps increase the secular sector? I guess it's probably you're horrified by that suggestion, but I'll bring it up anyway.
I don't know that I'm horrified in it. I guess I would just say I'm much less interested in these establishment clause questions than free exercise questions. The questions that I work on with Cornerstone in the constitutional area tend to be free exercise questions. And I think that was the origin of that Madison quotation in the original bill yes, it's just that Madison was saying that the free exercise right, which Madison drafted, by the way, should be enforceable like any other right. But of course, all of that language specific to religious liberty will be removed by the amendment, and the amendment will simply broadly address civil liberties.
Okay, thanks.
Representative Kelly?
Thank you, Mr. Chairman. Thank you for taking my question. Can you tell me, was the Binford case taken to the Supreme Court?
No, it wasn't taken to the Supreme Court. I would say that there are a few reasons that the House should go ahead and address this issue, even though it hasn't yet been taken to the Supreme Court. One is that this has been a very influential case. We've seen it cited in other Superior Court cases by an influential and respected judge who's clearly particularly influential in the area of constitutional rights and how they apply to states of emergency. Governor Sununu himself has repeatedly cited the Binford case in his emergency orders. And of course, this was argued by our Solicitor General. The briefing calling explicitly for courts to hold that constitutional rights can be suspended in states of emergency was written by our Solicitor General. So there are, this is certainly a theory that has a lot of currency, even though it hasn't been taken up to the Supreme Court yet. And I think that it would be best to, rather than waiting for this to get out of control and for a future, potentially quite intrusive situation to play out, for the House to enact this reasonable limitation on the scope of the emergency power statutes that, would not undermine most of what the governor is doing, but would just bring us into line with other states like Maine, where courts are still doing regular constitutional analysis in these cases.
Thank you.
I guess that begs my question, really, and that is, as I understand the amendment, and again, I don't have the amendment in front of me, and I'm sorry, but as I heard the testimony is that the amendment has a couple of paragraphs, but more specifically, it indicates that constitutional civil rights will not be set aside or infringed by the exercise of the governor's emergency powers, which is different than the idea that if the governor does exercise his emergency powers that affect constitutional rights, that the standard of review should be put in place that basically says he has to have the state has to prove that there's a compelling interest to do so. And which seems to have a lot more appeal to me than the standard that might be in this amendment. And I'm just wondering if that's something that possibly could be changed in time for us to act on this bill in a timely manner.
Well, Cornerstone would certainly have no objection to the removal of the word infringement, but I would point out, obviously, there are many rights in the Constitution that use that word infringe. And of course, what that means in practice is not that if I bring a First Amendment case, the court, automatically, as soon as my speech is burdened, it gives me an injunction. What it means is just that the court will do ordinary strict scrutiny analysis. And I also think, Chairman Gordon, if you read through the whole amendment, there's a lot of language about its purpose. And I think you'll probably agree that the purpose of it is just to ensure that ordinary constitutional analysis is applied. And not to, certainly not to enact any higher standard in times of emergency. All of the purpose-oriented language is about the fact that the general court in this bill is saying it wants regular constitutional scrutiny to be applied. But at the same time, if that's a concern, from my perspective, taking out the word infringed wouldn't undermine the amendment. So if that's something that would make others more comfortable with the bill, that's not something that certainly Cornerstone would object.
Thank you. Are there any other questions for Mr. Hewitt? Seeing none, thank you for your testimony today.
Thank you.
The next person is J.R. Hoyle.
Good afternoon, committee. Chairman Gordon, good to see you, Representative Smith. And who else did I see? I saw Representative Birch in there at one point with a really cool background. For the record, former Representative J.R. Hoyle, currently the Secretary for the New Hampshire Firearms Coalition as well. I speak both as a citizen as well as a board member for the New Hampshire Firearms Coalition. And I want to talk about both the bill as filed as well as the amendment. So I'm going to do the bill as filed. We think there is value to the bill as filed. I appreciate the case law for those who are attorneys on in this meeting, you guys love case law. That's great. I love statutes, but that's probably due to the fact that I spent 8 years helping write them. And I think citizens go to statutes first and they do case law. So if there was still value in having this, even though the MAC decision is good, having case law, in my opinion, is even more valuable. Regarding the, so I'm speaking, that's for me speaking as for myself. Regarding the amendment, I think the amendment is really clear in terms of the changes to RSA 445 and 47 in sections 6 and 7 of the amendment, that the protections outlined in the Constitution, and be that the Second Amendment, Article 2A, right, be that our free speech protections, should never be stepped on, even in an emergency. When our founders drafted the Constitution, they thought about things like this. And it was only in the 1980s that we bothered to strip some of this language out. Article 43 in part second actually removed the language infectious distemper from what the governor had authority to do in 1980. So it was clear that the founders realized that infectious diseases are in fact a real issue. They need to be dealt with appropriately. And the governor should be the first one to call the legislature back into session for the purpose of having policy decided. And that's an appropriate separation of powers. If I go to part first, there's numerous sections where the suspension of laws should only be by the legislature and not by anyone else. But that's where we are. So the question was raised, is this an over-the-top change? No, I think this is an appropriate level change to the emergency powers. Know that the governor can always call the legislature back into session and say, hey guys, we have a problem. And I could think of problems that exceed the COVID restrictions. Let's just say Seabrook, heaven forbid, but Seabrook had an emergency shutdown problem and there was a slow leak, whether it was a leak in the primary loop or a leak in the secondary. That's a real emergency. And I think everybody on this that's participating in this hearing would understand that that's a real emergency. And the right thing to do would be to call the legislature back into session, because we may have to move everybody who's over in that section of the state away, or who knows what. So it is important that the governor call on the legislature, but at no point should we ever allow the executive branch the ability to suspend our constitutional protections. I'm gonna use the example that Attorney Hewitt just said, right, about what if the press was stirring up a controversy and the governor just said arbitrarily, well, we're going to prevent them from participating at that event. My God, I can't think of a worse offense than shutting down the free press. If the press cannot report on what's going on, you're going to get a very biased story from somebody, and it's not going to be the free and fair press. So this small change is adequate. It's clear. It puts, and I've seen the amendment, it puts reasonable constraints on the emergency powers as they are in statute. It doesn't completely repeal them. It doesn't over the top wholesale them and change them dramatically, but it does put in reasonable protections to note that the rights that are outlined in the Constitution, the quote, thou shalt not overstep these bounds, unquote, language, which is pretty clear in the Bill of Rights, is off limits during these emergency shutdowns or emergency orders. So I would ask that you would have passed both the bill as filed. In my opinion, they should be merged, but that's me as a novice. And there may be others who have different opinion, but at least sections 6 and 7 should be added to the original bill, because our constitutional protections are kind of the baseline, the foundation of an understanding between the citizens themselves and those that are elected in office. So with that, I'll end my testimony. If there's any questions, I will gladly take them. Thank you to all.
Representative Birch, do you have a question?
Yes, thank you, Mr. Chair. Thank you, Representative, and thank you for your kind words earlier. Using the example of Seabrook, let's say Seabrook is not having a teeny weeny leak. Let's say Seabrook is melting down.
Okay.
And the governor even in your scenario, wishes to call the legislature back to session, let's say that will take 24, 48 hours. Is it your position that the governor should not be allowed to issue an immediate order saying nobody shall be within 1,000 feet of Seabrook as it's spewing forth radiation?
Thank you, Representative Birch. I like, for the record, I liked your former background better than this one, but they're both very good. The background of the State House chamber was really cool. I can see that saying that no one should be within 1,000 feet of Seabrook is reasonable. But back to my example about the freedom of press, I don't think the governor should be allowed to say, well, but the union leader can't report on what's going on because this could create mass hysteria. I think having real information provided by an independent outside private organization known as the press, whether that's people on blogs or whether that's newspapers or media or TV media, I think there's real value in making sure that that everything outlined in the Bill of Rights is clearly protected. Did I answer your question?
I wasn't really talking about the media. I was talking about barring individuals.
I'll give you the 1,000 feet. The governor could clearly call the House and Senate into session immediately. Concord may not be close or maybe too close, given your hypothetical, and we have to meet up in, I don't know, Bretton Woods. And it may take a week to get that orchestrated. But in that same time, right, I go through the list of things that are in Part First, Article 1 through 39, and I'm not sure when I read these protections outlined as the Bill of Rights, right, that we should be suspending any of them.
All right, thank you.
Any other questions? Seeing none, thank you for your testimony today.
Thank you, Chairman.
I'm going to we have two more people who have signed, have their hands up to testify. I just want to say that I'm going to recess the hearing briefly at 2 to allow Representative Smith just to address the next bill because she has to go to a memorial service this afternoon. And I want to let her have an opportunity to do that. And then we'll come back and finish this hearing as soon as she does that, okay? And the next person to testify is John Schmidt. Mr. Schmidt, you may have to unmute. Thank you. Mr. Schmidt, you there? Hello, Mr. Schmidt. For some reason, I'm showing him on the screen, but not hearing anything. So what we'll do is we'll go on to the next witness and come back to Mr. Schmidt. The next witness is Mike Thornton. And Mr. Thornton, can you hear us?
Yes, sir. Now I can. Thank you, Mr. Chair, representatives. I'm Mike Thornton from Milford. I am a member of New Hampshire Firearms Coalition, a member of Pinnacle Mountain Fish and Game, and Go New Hampshire. I speak as a private citizen. I will not speak in hypotheticals, but in absolute historical fact. The event was Katrina down south, and the authorities acting on emergency powers went in and forcefully disarmed peaceful people doing nothing but protecting their own property and not even brandishing firearms. In one famous instance, a little old lady remarked to an officer that she would be fine. She had a revolver. The officer knocked her to the ground on TV, knocked her to the ground, and forcibly disarmed her. She then had to be evacuated. This can't be allowed to happen, not in a hypothetical. in a situation where civil authority is no longer able to protect the citizens must not be prevented from protecting themselves. Part of that is the First Amendment. They have to know what is happening around them. There must be freedom of speech. There must be informed decision-making. That's the very foundation of our document that said, we the people. You take that away, and there is no body, no person, the House, nobody has legitimacy anymore because it is no longer we the people. With that, I will take questions, and thank you for your time.
Thank you for your brief testimony. Appreciate it. Are there any questions for Mr. Thornton? Seeing none, again, thank you for your testimony. And again, I'm just going to try Mr. Schmidt and see if Mr. Schmidt's available to speak briefly. Mr. Schmidt, are you available? Can you hear us now? Mr. Schmidt, can you hear us? Doesn't seem to be working. Is there anybody else who wanted to test? There are other people. So what I'm going to do is I'm going to recess at this point in time the hearing on HB 440. And as I said, we are scheduled to have a hearing this afternoon at 2 o'clock on HB 418. And the sponsor of that bill, Representative Smith, has to go to, will not be with us much longer. And so I'm just going to let her introduce the bill, and then I'll come back and we'll finish our hearing on 440. So Representative Smith, would you like to introduce? I'll call to order House Bill 418. And Representative Smith, would you like to provide your testimony?
Thank you very much, Mr. Chair. I appreciate your courtesy. I am here to introduce House Bill 418 relative to Supreme Court reporting. This is a bill that I submitted at the request of the judicial branch. I don't want to say it's a simple bill or a housekeeping bill, because we all know when you say that makes every legislator nervous. But what this is a bill that acknowledges the changes that have taken place in how we keep records, how we share records, how we report records. And I cannot be more pleased to see that it is at least one example of the third branch of government wanting to move itself into the current century or the current decade. Sometimes that is a branch that's a little slow to do that, and that they are acknowledging changes right now, I think is something that shows great progress and something that would be important and valuable for state government without in any way compromising any of our rights or access to information. All that this bill does is acknowledge that the system that was in law for producing documents might have outlived its usefulness, and its cost is significant. I am pleased to see that for this bill, Representative Birch has decided to move from the State House or a lovely outdoor site to a law library. And he, I hope, does that to recognize that what this bill does is to make it possible to use modern means of technology to distribute information about the work of the court. And I would ask the committee to support this legislation that, as I say, was submitted at the request of the judicial branch. Thank you, Mr. Chair.
Thank you. Are there any questions? Oh, there is a question. Representative Birch.
Thank you, Mr. Chair, and thank you, Representative and Madam Chair, for taking my question. It'll be very brief. As I read the bill at line 16, it would allow the Supreme Court to eliminate these volumes that you see virtually behind me. And I may be an old traditionalist and the like. Is that the intent of the bill, to say that these kind of volumes will possibly no longer be published?
I think that that is, in fact, a possible alternative. If I had more skill with Zoom, I would immediately change my background to one of my library to show how I value the written word and do not value the absence of a book in my hands. But I would ask, Mr. Chair, that you might recognize Lori Platt, who is here and represented the court, who would be able to, I think, answer Representative Birch's question with more accuracy than I could.
Thank you.
I'm going to recess this hearing when you're done speaking, and then we'll come back and finish this hearing. And I definitely will will call upon Attorney Platt at that time.
Thank you. And again, I thank you for your courtesy, and I do apologize for leaving the hearing early.
Not a problem. Thank you. Okay, I'm going to recess the hearing on House Bill 418. And having had it introduced by Representative Smith, and go back to our hearing on House Bill 440. And I'm going to try one more time, John Schmidt, to see if we can get him to participate. Mr. Schmidt, can you hear us at all? Can you speak? Can you unmute yourself? It doesn't appear that you're muted, but doesn't seem to be working. And is there anyone else who hasn't testified on House Bill 440 who wishes to testify on House Bill 440? There was someone else who appeared to have their hand up earlier. But I don't see anyone. So that's fine. We'll close the hearing on House.
Representative Honorable Hull had a comment to add in.
Okay, yes, you'd like to be heard again?
Thank you, Chairman Gordon. I want to point out for the record that my hypothetical example was an extreme one, and it was. So we should note that a meltdown at Seabrook is a serious issue. The most serious I could think of on the spot. So I would wish that on no one. And I just wanted to make that for the record. I was just picking the most extreme example I could think of for a state of emergency. So thank you, everyone.
Thank you. And with that, I'll declare the hearing on House Bill 440 closed and go back and reopen the hearing on House Bill 418 and call upon Lori Platt to testify. Attorney Platt, are you there? I don't know what's happening here. I don't know if you're muted on your end.
Perhaps the clerk could try in case there's some problem on the chair's end.
Jen, are you there?
I am. The only thing I can think of is I'm going to try to promote her and see if that makes any difference for
That'd
us.
be great.
Attorney Platt, you're unmuted if you could speak.
Is her computer volume all the way down, maybe?
Yeah, that's all I can assume is that there might be a mic problem on her end. There is a mic connected. Oh,
She's connecting.
It says.
she can obviously hear us.
Attorney Platt, it looks like you might be muted. Can you? Do you, perhaps if we're not connecting this way, perhaps you could call in. In the meantime, is there anybody else who wishes to speak on this bill? Mike Thornton, did you want to speak on this bill, or were you, I know you spoke on the last bill.
Yes, sir, Mr. Chair. I do wish to speak briefly on this bill as well.
Okay.
If you look at George Orwell, 1984, the first thing they did is they got rid of the written word so that history could be changed at any moment and no one would be the wiser. I'm not saying have tomes of useless paper lying around, but there needs to be an immutable trail that any citizen can access and rely upon, that there is a reliable source of any changes to law or fact for the protection of the entire public. Thank you very much.
Thank you. Any questions for Mr. Thornton? Seeing none, thank you for your testimony today. And
Representative Gordon, my only last idea would be if Attorney Platt happens to have connected by phone, to raise her hand with *9. I just see one call-in user, but I'm not sure that that is her.
Yep. There's a hand.
You can try.
Yeah, is that you, Ms. Platt? You have to unmute.
Unmute using *6.
Yeah, *6. There we go.
Can you actually hear me? Oh, thank you.
If you just mute your computer, because we're getting a little feedback.
Now is it working?
Mm-hmm.
Yes, much better.
Perfect. Okay, thank you very much. First of all, I'd like to thank Representative Smith for sponsoring the bill. I believe, Representative Birch, while we were scrambling to try to unmute me, you asked the question about whether we were going to do away with printing the books. Okay. That may be the goal eventually, but right now what we're trying to do is make our opinions more accessible to everyone. And so this bill would accomplish two things, and can I just discuss one very minor point? This bill would also make the statutes gender neutral. Right now, they refer to the reporter as a he. But the other is to allow the court to move from publishing its decisions in bound volumes to having the ability to publish the official version online and eventually to have the opinions on our website be searchable. The current intention of the court is not to do away with publishing the volumes, but you should know that the demand for published volumes is going down. So as a result, the price for publishing them is in all likelihood going to increase as we go forward. I think it will take some time to do this. Certainly, I've met with Terry Pfaff and Scott Kelly because we're hoping to develop some sort of searchable database, much as you have the bill status search capability, which you may or may not know was developed by your own IT staff, I believe. So I do think that eventually we will not have printed books, but that's not something that I see as happening immediately.
Yes, Representative Sylvia.
Thank you, Mr. Chairman, and thank you for taking my question, Attorney Platt. A previous speaker spoke to the possibility of an immutable record, and I know that the technology is coming around with all the blockchain stuff that goes on. Is there an intention or a thought or consideration toward assuring that the original source is maintained in some fashion where it can be known that it is the original?
We actually have a study committee, or I gather it's a working committee with our law librarian who is looking at that exact issue, among many other issues. So it's definitely something that is on our radar, so to speak, and it definitely would be considered as we move forward at perhaps a somewhat glacial pace.
Thank you.
Yes, Representative DiLorenzo.
Thank you, Mr. Chair, and thank you for taking my question, Ms. Platt. So looking at a scenario where the law books would be no longer published, would the public have access to the online information? I mean, free access?
Yes, thank you. That is a great question, and that is the goal. The public would have access and does have access right now to court opinions, but the general public cannot search the opinions on our website. So, for example, if you were looking for a case involving, DUI convictions, if you don't have access to a commercial search engine, you can't search our opinions. And so we'd like to the court's goal is to make the opinions on our website the official version, and also at some point to develop a search engine so that members of the general public can actually look at those opinions and find the topic that they're looking for.
Thank you.
Other questions? Do you have a time frame for when you think this is going to happen?
We would hope that it really ought to begin at the beginning of a calendar year, just because there are a number of different factors that are involved. And so if this bill were to pass, we would begin meeting this summer, and by January, hopefully, the goal would be to declare the opinions on our website as the official version. That doesn't mean we would stop publishing the New Hampshire reports. I don't see that happening based on my conversations with the court for some time. In fact, we have a publication contract that covers the next few volumes of the New Hampshire report. So that's why the bill is drafted as it is, so that there's an overlap for some time.
If I could just follow up on that. So is there a need right now to indicate that the reports can be either in the form of
the written form or on the website form, as long as you're authorized to do it on the website.
Well, I mean, the court would like to declare that the opinions on the website are the official version. So
Okay.
I'm not sure that I understand your question.
Well,
What would you?
I don't see anything in here that says that the reports are the official version. It just says the reports may be published either in volumes entitled the New Hampshire Reports or on the Supreme Court website. So there doesn't seem to be anything. And so if I read it, actually, if I read it literally, that means it can be one or the other. But I'm presuming that it could be both. I guess if you give you the authority to put it on the website, it isn't necessarily making it the official opinion, is it?
Not immediately, although that would be our goal I think that would be the goal. Again, I don't know how long it's going to take to develop the search engine. So Section 2 of the bill talks about amending RSA 505:8, and the proposed amendment, Rome 3, would allow us to publish in volumes as well as on the Supreme Court website. There'll be an overlap for some period of time.
Okay. Any other questions? Seeing none, thanks for your testimony today.
Thank you very much.
Okay. And is there anybody else who wishes to testify today who hasn't had that opportunity? Seeing none, we'll close the hearing on House Bill 418. And is there any other business? I know for the Republicans, we do have a caucus on Sunday afternoon from 3 to 5. And is there any other business that we need to take care of today? No? Well, thank you all for taking the time today. I know it's been a full week. The legislature's become a full-time job here. And I don't know, as somebody's mentioned, a couple of different people have mentioned the emails, but when I got home last Friday, I had over 1,000 emails in my box. And I'm sure you're all getting inundated as well. Yes, Representative Chase?
Yes, I was just wondering if there's a pay raise in our future.
I wouldn't count on it.
Funny you should mention it. I'm co-sponsoring a CACR with Reverend McWilliams, and the effect of that would be to take out the $100 a year from the Constitution, which at the time was 1/20th of the governor's statute, and then let the legislature determine it by statute. That's an idea that's not seeming to be met with much enthusiasm. I don't think we can get past the 60% of the membership of the House, let alone 60% of the Senate and 2/3 of the people. But it's a remote possibility, but that would not take effect for a few years, even if it goes anywhere. So
can't say remote and legislature at the same sentence.
No. Yeah.
I'm taking all of this as a no. I will not see an extra paycheck.
No.
And it's not looking that way. And actually, we're not getting the mileage checks this year for Zooming. So that's the way it goes. And not only
more work and a cutback. Yeah, got it.
And not only that, if you're retired and you have money in the stock market, it's been a very bad week as well, I might add. So. Anyway, we'll see you all next Tuesday.
Thank you, Mr. Chair.
Thank you, Mr. Chair.
Have a great weekend.
Take care. Nice weekend.